protect our nation during these trying times. In Jesus' name we pray. Amen.
Good. Thank you very much, Minister Marsha Smith. Any apologies for absence, Grayson? Okay.
No apologies.
No apologies. First of all, let me welcome everyone who is online. I know that a number of members of the Joint Select Committee will be joining us shortly, but I think we now have a quorum of 4, so we can begin. Just to indicate to the presenters today that the private sector organization, Love March Movement, and the Lawyer Christian Fellowship, that bear in mind you have basically about 15 minutes for your oral presentation, and then the NITS team will respond. I can assure you that the NITS team have circulated your presentations, and in addition, the NITS team have also prepared a detailed response to all of your, to each of the items that you raised in your contribution, so that there also your written submissions have been circulated to all members of the committee and others. And so they will play a part in the deliberations of the committee. So I'm just going to ask the presenters today, the first 3, to highlight the main issues. Immediately after that, we're going to want to thank Jamaicans for Justice for just delaying by an hour. So with the first 3, we want to finish within the hour so that Jamaicans for Justice can finish up their presentation. And I hope Jamaicans for Justice, we're giving you not more than half an hour to complete your presentation, which will then allow the NITS team to respond. And hopefully by about midday, we can have a fulsome discussion for about an hour, so we can finish by at the latest 1 o'clock today. Now, the minutes of January the 27th and 28th, although they are been circulated, they were only circulated yesterday, so we're going to put them off and their confirmation and matters arising from them until our next meeting. And when our next meeting, probably in another 2 weeks' time, we'll give at least another week so that we can all collect all the minutes, collect all the documents when we will start our deliberations on the various clauses in the bill. So to begin with this morning, we're going to be asking the private sector organization of Jamaica to highlight their issues. You have not more than 15 minutes, members, so that we can start. So if the private sector is ready, could you just please turn on your video and your audio and indicate who is with you and start your presentation.
Thank you very much, Minister. Good morning to everyone. Can you all see me?
Yes, we see you very well.
Hi, good morning again. I'm Jackie Sharp, Vice President of the Private Sector Organization of Jamaica. And with me, I have Chuck Cameron, who is an attorney at law and also a PSOJ member. So thank you, Minister, for giving us this opportunity to provide our feedback on the NIDS Act. As you know, at PSOJ, we are fully supportive of NIDS because we see the long-term positive impact it can have on our people and our economy in the long run. So we are very happy to be participating. We formed a committee, a subcommittee within the PSOJ to review the act, and coming from that deliberations, we submitted some recommendations. And so I'm now going to hand over to Chuck Cameron, who is our key legal person on our subcommittee, to just run through the highlights of the sort of recommendations that we had made and try to stick within the 15-minute time frame.
Thank you very much, Jackie.
Over to you, Chuck.
Thank you very much, and good morning, members and Vice President. So I'm not going to read out the relevant sections. I'm just going to identify the issues that we have identified while referring you to the relevant section. So if I may first draw your attention to section 5, subsection 4F. in general, we have found that leaving the head of the entity to have the power to do anything, it is a bit wide. And in circumstances where the actions of NERA has the ability to, well, does restrict the right to privacy, we do want the powers to be very specific and not leave the head of the organization with the power to do anything in support of the stated objectives. We'd prefer if that wording be more specific or just deleted altogether in light of the fact that his actions, by the nature of his responsibility, does significantly restrict the right of privacy of Jamaican citizens. If we were to move on to section 6.1b, in terms of consistency, we would suggest that we want to keep the language consistent with the Data Protection Act. And instead of using the word identity information, we are recommending that we use the word personal data. And the reason for that is that under the Data Protection Act, certain rights accrue to data subjects or citizens as it relates to personal data. So if it is intention, well, so we do want to have those rights accruing to all personal data that is being collected under the under this legislation as well. Moving to section 6.1e. This is one of our major issues. We do not see the inclusion of any parliamentary oversight, and we're of the view that this is inconsistent with good governance practices and administration. So what we have seen is that arrangements, the minister has the discretion to put arrangements in place, and it is a minister with responsibility that the buck usually stops with. Given the extensive reach of this legislation, and again, the extent to which it does restrict the right to privacy, we're of the view that Parliament ought to have some oversight role as opposed to the minister alone. This is further reflected in section 7, and our position simply is that too much power resides with the minister. The reporting framework is not clear on whether the authority reports to the minister or Parliament. So we are of the view that there can be much more clarity as to what the reporting lines are, and ultimately it should be overseen by a parliamentary committee.
Chuck Cameron, I can just briefly indicate to you that these issues, especially this one about the reporting, is a matter that has been brought up by many presenters. And I think there's a general feel that the oversight committee will be reporting directly to Parliament. So, you know, the inspectorate, we are going to revamp the inspectorate so it becomes an oversight committee reporting directly to Parliament. Okay.
Appreciated, appreciated, Minister. And we do note the several layers of lines of reporting. So we do appreciate that, and so we're even further pleased to hear that intervention, sir.
Yeah.
When we look at section 9.7, subsection 7, that is, well, given this age of technology and digitization, if we could just expand or specify what legislators meant when they said it in writing, and hopefully it would include electronic and other types of correspondence. I'm going to jump very quickly to section 14 that deals with the duty to inform of processing after cancellation. What I missed one. Section 11.1a, this is just a general comment as it relates to gender inclusivity. We are recommending that it read gender of individual. If we were to jump now to section 14 of the legislation, this deals with, well, this is a technical issue, and based on the information that we have and that was presented in the legislation, this is the position we formed. We're of the view that this section focuses on the cancellation of a national ID card. We know that this is a physical object, but it doesn't necessarily speak to the digital implications therein. Specifically, the PSOJ would want to know what happens to the digital information that is shown on the physical card and the digital information that it represents. So whereas we note that the card would be cancelled, under the Data Protection Act, data subjects have a right to know what data is being processed. So the legislation needs to actually set out what is going to happen to the underlying information and not just what happens to the physical card once a card is cancelled. Is it that once a card is cancelled, all the information remains on a database, or is it that it is stricken or removed from the database?
No, once it's cancelled, first of all, the card has to be returned to the NERA, but the information on the database is removed. Okay, in other words, if the PSOJ or any member of the PSOJ wanted to authenticate something for that individual, they will be told that it no longer exists on the database. Okay, so that would be effective.
In terms of the process, would it be left up to the citizen to attempt to query something, or will the citizen be advised upon completion of the deletion process? Because the authority does have that duty to advise.
Now, once it's cancelled, the person will be told that the data has been removed from the database. Okay, so, you know, if they would be advised that it will be removed from the database. What is not cancelled, however, is that the national identification number will remain with that individual for life, forever, even death. Okay, so that if that individual seeks to re-enter, then that number will be revived because the card would have been surrendered and kept. You get me? So the card will be surrendered by the individual and will be kept. So in the event the person re-registered, the same number will be assigned to that person.
Okay.
But the information in the database will be removed.
One issue that may not necessarily be appropriate for the legislation, but possibly some regulation or some guidelines, is how would a data subject then satisfy himself that that information has been removed? Because that is a technical process, and when treating with personal data, there must be some level of transparency. So the committee may want to identify that process that can be independently verified or audited to say, yes, we have removed it, and here's a proof of removal. Because in that digital space, we know we can just press delete on a computer, but it remains there. So thinking through some documented process that can be independently verified, I think is if it has not already been considered, we are of the view that that process should be in place, that it could be independently audited and verified.
Well, I'll ask the NIDS team to respond to that.
Obliged, Minister. If we were to move on to section 23F of the legislation, that primarily speaks to, well, we see where you have recommended that all the data be encrypted. In keeping with the Data Protection Act, and in particular, 7th Data Processing Standard, that legislation speaks to encryption and pseudonymization. And the thinking behind that, well, it is our position that this legislation ought to also promote the pseudonymization of the data. And the thinking behind that is, while encryption really protects data if it's leaked outside of the organization, we really also need to be very conscious and aware of the internal threat actors, because very often it is usually members within an organization either by mistake or intentionally that cause data leaks. And so where we adopt pseudonymization of the personal data, it offers an extra level of not only external protection, but internal protection. So it is, while the operators of the system need to be able to access certain information, everybody does not need to be able to see, doesn't necessarily have to see everything. So we are strongly recommending that in addition to all the personal data being encrypted, it is also pseudonymized.
Okay.
It is contemplated in this legislation that the information would be shared among third parties.
No. There's no question of sharing of the information in the NERA with anyone. What the NERA will be able to do is to authenticate requests from the banks, institutions, or any other government agency. But it's not a question that the data, let us say the data will be passed on, any individual data will be passed on to anyone. The only provision is in section 24, where the commissioner of police must go to a judge if they want any specific information. That's the only provision, section 24. Okay.
Thank you very much, sir. And it is, well, I should have been more specific. It is in relation to that accessing of information that we are concerned with.
All right, let me just clarify section 24, because in section 24.3, section 24, it speaks about any other law, coming to you in a second, or, as may otherwise be provided by this act or any other law. I think we have had a discussion on this, Chuck Cameron, and we want to say there that if information is to be provided by any other law, okay, that information will only be provided in a similar manner as the commissioner of police gets his information, that is by going to a judge. So to give you an example, let us say there's another institution, MOCA, that provides that, it could access information. Then MOCA head or FID head, or any other law that provides for the information to be revealed, they would have to do a similar procedure like the commissioner, appeal to a judge, ask the judge that this information is important for in the national security, etc., or for the prevention of crime. And in those circumstances, that is the only basis on which specific bits of information could be released in accordance similarly with section 24.3. Okay.
Thank you very much, sir. We are very comfortable with the legal basis in which information will be shared. What we are particularly concerned with is, having obtained that lawful order, what is the mechanism or the organizational measure that is put in place to ensure that data is shared in a safe manner, and once it comes in the possession of that third party, that the appropriate technical organizational measures are put in place. And to that extent, we are of the view and recommending that, consistent with the Data Protection Act, certain data sharing agreements be put in place, where obligations to maintain the data in a certain manner, and the whole question of the length, a period of time that this data will be kept and how the data will be processed will be captured in this data sharing agreement. So one, having established a lawful basis, NERA needs to satisfy itself that how the data will be treated after it leaves its possession would be maintained and processed in accordance with best data processing standards.
Well, the position is that section 24 also indicates how the data will be treated and how it will also be destroyed. And section 30 emphasizes that the confidentiality, and if it is not protected, then persons could be fined significant sums of money, you know, if the data is in any way released at all. Okay. The Section 30 is a protective mechanism to ensure secrecy and confidentiality of the data that is shared, say, with the Commissioner of Police or under any other law, as we say, we will ensure. Okay.
So, obliged, sir. One of the beauties of the Data Protection Act is that outside of, well, it has really broken down into biteable sizes. How do you enforce confidentiality? How do you secure data? So we have always had the financial regulations that said that data should be treated confidentially. We have always had regulations that govern attorneys that says data should be treated confidentiality. What the Data Protection actually does, it actually sets out certain data processing standards that ought to be maintained. So it is those data processing standards and security measures we are of the view that should properly form part of a data sharing agreement.
Let me say, Chuck, that this NERA will be subject to the Data Protection Act. Okay, in fact, you will recall that the Chief Justice in Robinson's case emphasized the need for the Data Protection Act to be in place before any similar act as the 2017 Act. And so all the contributors, or many of the contributors, have indicated the need for the Data Protection Act to be in place before the NERA is actually executed. So we're aware that the Data Protection Act will protect, and the NERA will follow all the confidentiality and protective mechanism of the Data Protection Act. Okay?
Obliged, sir. I will move on to another section in section 24. And the issue we have here is that it is unclear in what manner and form the identity. Okay, so I think we have belabored this question of data sharing sufficiently. I will move on to section 24, subsection 7, subsection B, that speaks to the verification of the removal of data. And I'd raise this issue in relation to one of the sections I've made reference to previously. So I'll not go over this again. So I'm now referring the committee's attention to section 30, subsection 2. And this is a section that deals with criminal liability for employees.
Right.
And we know that there has been a lot of discussion, and you have got a lot of feedback from the public on this issue. We have a very strong view on this question, Minister, and it is our view that employees of NERA should be faced with the same, if not greater liability than members in the public sector. Under the Data Protection Act, any data controller company, any employee of any company can be faced with criminal sanction.
Well, I can tell you that previous contributors urged us to look at the penalties for the members of staff. In fact, some persons have even indicated it should be a mandatory prison term. So the Joint Select Committee will be looking at the penalties if data is unlawfully shared. Okay. And well, we are just suggesting there should be equity. So where members of the private sector are faced with criminal sanction, even when it's not unlawfully shared, if there's an error or a mistake and negligence that caused some data processing breach, we don't think a government entity whose core business is processing personal data should have any less liability than members of the public whose core business is not necessarily that of processing personal data. So we would also invite you to take on board that principle when making that determination. That is a remedy that has been suggested, like you, by other contributors. Okay.
Yes, sir.
That's been looked at.
And finally, as it relates to schedules 1 through to 3, we note that there is no limit on the number of terms that board members may be reappointed. There is on the table, but has not yet been promulgated, the Public Bodies Management and Accountability Regulations that has recommended that board members be reappointed for a specified term. While we note that this has not yet been promulgated, we are of the view that the board members in this instance, again, just to inure and promote good governance, board members be given a fixed term, whatever that may be, but an agreed fixed term, and not be able to run without more and in an unended manner. Those represent the primary concerns of the PSOJ. As Mrs. Sharp has indicated, we are strongly in support of the legislation, as we do see and know the need and the impact it will have on our economy and society. Madam Sharp.
Just Chuck, that the NITS team, we want to thank you and the PSOJ for those points that you have raised. The NITS team, in fact, have prepared a detailed response to all these points. And then if there are any additional points that was raised by you, Kamika, could you just respond briefly to some of the points raised? And then we will also get this detailed response to you, Chuck, and the PSOJ, so that you can see that your submission was thoroughly considered and a response was provided to them, okay? But orally, I think Kamika Face will highlight some of them. Go ahead, Kamika.
Good morning, Minister. Mrs. Miller-Williams will actually be taking both PSOJ and the Love March movement today.
Okay. Janelle, would you go ahead then and give the response?
Thank you for that, Chairman. Okay, so in responding to PSOJ's submission, I will start off with Clause 5, the National Identification and Registration Authority. They had identified an issue to state that the authority's power is too wide and unrestricted, which unnecessarily threatens the right to privacy of the citizen. And that the word anything is too broad, and that the legislation specifically sets out the power that it wishes the authority to have or to be deleted. So this issue was highlighted in previous submissions, such as the Norman Manley Law School. And we had responded that this clause is intended to facilitate the efficient operations of the authority in the performance of its functions. And as such, the authority will have to utilize these powers within the parameters of this legislation, the Constitution, and the laws of Jamaica. With respect to Clause 6, Board of Management, the submission had indicated that the language is inconsistent with the Data Protection Act, which speaks to personal data. And it was suggested that the definition of identity information as set out in the authority be aligned with the definition of personal data in the Data Protection Act. And at this time, I will refer to the Chief Parliamentary Counsel.
CPC, Judith Grant, are you on?
Yes, Chair, good morning. So identity information refers to information that might be required by the authority for the purposes of enrolling an individual in the National Identification Database. And it's the information that's listed in Clause 11. The concept of personal data, though, under the Data Protection Act is much wider. It's any information about a data subject that from which the data subject can be identified, whether by that information alone or that information together with any other information that is in the possession of the data controller. So that is much wider, and so it would not be appropriate in this context to import that definition, because that would be doing is empowering the authority to collect any sort of that type of information. But if you look at the items that are listed in Clause 11, you can readily conclude that all of those things are things that would constitute personal data within the meaning of the Data Protection Act. So by virtue of that, the authority would be a data controller for the purposes of the Data Protection Act.
Thank you.
If I may I comment, or shall I wait till all of them have?
Just let Janelle finish and then you can respond. Go ahead, Janelle. Are you finished?
Yes, yes. Okay. So in relation to the comments at clause 6 and 7, the Board of Management and Ministerial Directions, the chairman had already indicated that the committee wishes to, or has the intention to review the governance structure and the oversight framework. In relation to clause 9, national database seals, the clause 9.7 states that the authority shall in writing notify the individual, and the submission had indicated that the term in writing is too vague in outlining the various formats for communication, and they had recommended that in section 2 of the Act, a definition of in writing, which could include any form of electronic, digital, or print correspondence. And our response is that section 7 of the Electronic Transactions Act indicates different forms of writing which are recognized under Jamaican law. With respect to clause 11, identity information, they identify the issue of gender inclusivity, and they had suggested that we can restate to read gender of individual. But our response is that the bill is drafted in keeping with the recognized sexes stated in the Constitution, being male or female. With respect to clause 14, cancellation of enrollment, the suggestion was that in accordance with the first data processing standard, the authority as a data controller has a duty to inform persons whether digital identity information is still being processed after cancellation. And clauses 14.3a and 14.6 state that upon cancellation of enrollment, the card must be surrendered and the national identification number shall no longer be utilized by the previously enrolled individual. Further details will be encapsulated in regulations as appropriate. Furthermore, identity information collected will be retained in accordance with the provisions of the Data Protection Act and in accordance with the applicable retention schedule. With respect to clause 23, security of information, it was stated that encryption may not be adequate to ensure the confidentiality, particularly when information is being shared with a third party, right? And so it was suggested that information should be encrypted and pseudonymized. A similar issue was previously raised by 876 Solutions as it relates to anonymization. The committee may wish to consider this recommendation to provide for all 3 levels of securing data: encryption, anonymization, and pseudonymization. The authority, though required to utilize these security mechanisms, must be left with the discretion to apply the levels best suited to the specific circumstance. In respect of clause 24, disclosure of identity information, where it was suggested that there should be more detail in outlining the process for this destruction of information. This issue has been highlighted in several submissions, and the committee has indicated its intention to address same. And also in relation to another issue, that data sharing agreements should be mandatory between the authority and other data controllers. Our response is that reference is made to clause 31C, which places a duty of secrecy and confidentiality on every person to whom information is communicated under the Act, to treat the information with secrecy and confidentiality. It also requires such person to not disclose the information unless in accordance with the Act or the administration of the Act, and failure to comply with this requirement constitutes an offense in the bill. Data controllers are required to operate pursuant to the Data Protection Act and the wider data protection regime. As it relates to data sharing arrangements, reference is also made to clause 5.4f, which purports to allow the authority to enter into arrangements, which may include those which were referred, and also clause 8, which requires the public sector entities to cooperate in order to effectively administer the act. In relation to clause 30, secrecy and confidentiality, in relation to your suggestion, the committee also indicated its intention to revisit the offenses and penalties in the bill. And with respect to your suggestions at schedules 1 to 3, the committee has indicated its intention to revisit the governance and oversight framework.
All right. Thanks, Janelle. Chuck Cameron, you have a short response. And by the way, the administrator, a number of members of the Joint Select Committee are trying to get on. I know Donna Scott Monty said she was unable to get on. Is she on now? Donna, are you on? Okay, administrator, could you please let her in? Okay, continue on, Chuck.
Yes, sir.
No, Minister, I'm in. I changed my device and I got in.
All right, wonderful, Donna, thanks. Okay, Chuck.
Yes, sir. Just one issue as it relates to the definition of identity information. If it is, there could be some language to suggest that the thinking behind that recommendation was that rights, the Data Protection Act is only invoked or only relevant to personal data and not necessarily anything outside of personal data. So if there can be some clear language that the same rights that accrue to personal data for data subjects is the same rights that accrue to identity information, that's a concern, that you can only invoke the Data Protection Act in relation to personal data.
I suspect though, Chuck, and Judith, you can assist me or member of this team. I suspect that every item, not only in every item, will be under the protection of the Data Protection Act. Isn't this the case, CPC?
Well, Chair, I had mentioned that looking at the list there, you would have to apply the definition in the Data Protection Act to see whether they fall there. And in my view, everything that's listed there would.
Right.
But again, that is really the function of the Data Protection Act. The definition there would have to be applied for any information for you to be able to determine whether that act applies.
Fine. All right. Is that okay, Chuck?
Yes, sir.
All right. I want to thank you for spending so much time to examine the bill, and thank you and the committee and the PSOJ for participating. Please keep in touch as we proceed to report to Parliament, to debate it in Parliament, and hopefully to execute the bill itself later on this year. Thanks. Do we have the Love March movement available now? Love March movement, are you on?
Come on, we're here. Good morning, good morning.
Right. Could you just state your name and who is with you, or if you're alone?
No problem. So I am Daniel Thomas. I'm the president of the Love March movement. With me today is Francesca Tavares. She's the vice president and attorney at law. So,
okay. Remember, as I said, you have a long submission. I don't expect you to read it. I expect you to highlight the issues. We have read it, and I can assure you there will be a detailed response that will be sent to you. But for your oral submission, I beg you to just highlight the main issues, okay?
Certainly, here, we will do our best to just highlight the main issues. So, distinguished chair, Honorable Delroy Chuck, Minister of Justice, and members of the Joint Select Committee, members of the staff and houses of Parliament, colleagues, good morning. We thank you for this opportunity to be able to share in this process. The Love March movement is a youth organization which, amongst other things, encourages youth participation in the political process and has contributed to the national dialogue in the implementation of the previously drafted National Identification System legislation. We really welcome the changes and the process that took place, which resulted in the ruling of the Supreme Court in Robinson. And at the same time, we would urge the government to re-examine the question as to whether or not NIDS is actually necessary, given the identification cards, etc., that we have currently. The government's website on NIDS states that NIDS will facilitate the simplification of the bureaucracy in the public sector and will contribute to the achievement of Vision 2030. But our position is that the government has failed to explain why the existing identity documents, such as the passport, the driver's license, electoral registration numbers, are insufficient for this purpose or could not be updated. And we're concerned that the decision to continue with NIDS, albeit in a reduced form after the decision in Robinson, is forcing it to create post-facto justifications to build the case for NIDS. We're dividing our submission into two parts. This will be the general recommendations, which will incorporate wide views covering a number of different countries, which we really think that we can learn from as we proceed. And then secondly, specific recommendations, which look at the proposed bill itself in the context of the Robinson case, and also highlighting things from the Indian experience, in particular, their Aadhaar system, which Robinson and the Attorney General, that was a significant case that was considered in the Supreme Court ruling. So I'll now hand over to Ms. Tavares to take us through.
Right. Thank you so much, Dr. Thomas. So I think to begin, we should examine the limitations of NIDS. It's important to understand the limitations of biometric authentication systems like NIDS, seeing that the objective of the Naira bill is to prevent identity theft and other instances of fraud with respect to identity information. It's aimed at strengthening identity security, cybersecurity, simplifying bureaucracy by combining the functions of national identification and civil registration within the authority through the establishment of the national databases. So the question to be asked is, will NIDS actually be able to mitigate the scale of identity thefts and frauds? And if so, how effectively? This will help us to evaluate the need for a new biometric identity system, such as NIDS, given the existence of other identity documents. So NIDS will not stop fraud or corruption, it may facilitate it. The rationale underlying the law is that biometric identity can't be forged or gamed, and therefore it's more secure than other existing forms of identification. However, the experience in India reveals that identity frauds are still possible under the digital identity systems and have not necessarily reduced. Since 2011 till 2019, 164 Aadhaar-related frauds were reported in India, including through the use of fake Aadhaar cards, for example, forging existing cards by replacing the photo, or using fake details to generate a new card. There have also been reported instances of the same person having 2 or more Aadhaar cards. So in view of the Indian experience, we'd recommend that this limitation be considered in light of alternatives which exist, which we will discuss later. Additionally, we have not seen any study or other data published by the Jamaican government regarding the scale of identity fraud in total and in relation to other types of fraud, and explaining how NIDS specifically will help reduce the instances of such fraud. For instance, in India, researchers documented 3 types of fraud in India's welfare system, and which was used for providing food to the poor, and they found that digital identities such as Aadhaar could only assist in mitigating the fraud in 1 instance. NIDS at best, therefore, can only help in reducing identity fraud, since the NIC and NIN can help authenticate the identity of the individual but cannot ascertain whether that person is entitled to, for instance, certain social welfare benefits, or if they have received the full quantum of that benefit. Similarly, the Indian Supreme Court struck down the government's measure of mandatory linking of Aadhaar to bank accounts, in order to reduce financial crime on the ground that there was no demonstrable proof that ADHAR could actually reduce financial crime or money laundering. Therefore, as NIDS will not address or solve corruption, fraud, or other criminal incidents as it's being promoted to do, again, we question its necessity and strongly recommend that if implemented, its utilization remains restricted to the stated purpose of authentication, as we discussed in our written submission. NIDS voluntary in practice. In keeping with the decision of the Supreme Court in Robinson, enrollment within the NIDS through the authority should be voluntary under the proposed law. And this is not just de jure voluntariness, but also de facto voluntariness. It's important to preserve and uphold the information privacy, autonomy, dignity, and choice of all Jamaicans. And so enrollment in NIDS must remain voluntary in practice. The stated objectives of NIRA are very broad. Therefore, it's important to bear in mind that in actuality, NIDS should remain voluntary. Therefore, in the future, the government should not make the availability of certain services, benefits, or subsidies contingent upon successful NIDS enrollment or NIDS authentication. Equally, the government should not create or facilitate the creation of a two-tiered system where access to certain public or private services will be dependent on or made more accessible if an individual has an NIC or a NIN, making other forms of ID difficult to use or functionally redundant. We believe that the government's decision not to interfere or regulate the use of NIC for facilitating any private voluntary transaction between...
Can I just interrupt you briefly?
Sure.
Can you tell us which other means of identity? We use the passport and the driver's license for system identification, but are there really ID cards?
You know, that's a very good question. We submit yes, but we're going to discuss further that there are other alternatives that exist that Jamaica, looking at the UK experience, for instance, that Jamaica could exploit to engage in the digital economy without establishing an NIDS, and it could actually be cheaper. It would run alongside the existing infrastructure as opposed to remodeling it altogether. It would also address actual, not fanciful citizens' concerns about government access to private data, government access and control. Yes, and that was the experience in the UK. We're going to discuss that in a minute. However, we are very concerned about voluntariness in practice, particularly with regard to the government's decision not to interfere in private voluntary transactions between two persons under Clause 17. A two-tiered system may be set up where individuals will be de facto forced to get an NIC in order to access certain services at all, or in a more accessible manner. For instance, making the NIC the primary means of ID, or the creation of administrative hurdles to other forms of ID. Persons may find themselves forced, and yourself, Mr. Chairman, you intimated at previous meetings that the NIC, the NID system would eventually subsume all other cards, which is very concerning. The impression that was given, Mr. Chairman, was that eventually all other forms of identification would be phased out. Therefore, with the passage of time, the enrollment in the NID system would become de facto mandatory, not voluntary.
But the point, Mr. Tavares, it is. Yeah, the point is that, I mean, you have maybe close to 1 million people in Jamaica now who don't have passport, driver's license, or any other form of ID. You will agree with me that those persons are deserving of an ID by which they can be recognized. You agree with that?
I would agree with you, Mr. Chairman. However, I believe that just as efforts... I'm sorry, am I interrupting you? Please continue.
No. What I'm just saying, the next thing, we know that driver's license have been duplicated, okay? We also know that there are persons who have one name for passport and another name for driver's license. So to the extent that, say, benefits are to be given to persons, if they have one name for driver's license, one name for passport, one name for electoral cards, then you see that person could get 3 benefits.
Thank you for that point, Mr.
Chairman, just
Chairman.
before you respond, Madam Presenter, Mr. Varus. Chairman, colleagues, I think this is going to be the most contentious that the government and the committee will have to grapple with, to the extent that the government has accepted the ruling of the court on the matter, the important constitutional issues. It is of significant, we have to appreciate the significance of the concern that where the law says that it is going to, it cannot be made mandatory, but a discretionary regime, then any concern that because of the perceived benefits, the ease of doing business, and the fact that life will be made easier for persons who opt to use a card, it is a valid concern that the state cannot, by other non-legal means, make life more difficult for those who have not opted in. If we accept the constitutional ruling and to the ruling as legislators, this is a concern that we will have to grapple with.
Okay, thank you. Okay, just finish up, Mr. Varus. Go ahead.
Thank you, Madam AG. On that point, Mr. Chuck.
Before you move on, Chairman, before you move on, I have a query just for clarification. The NIDS card will be clearly taken voluntary by those who want to take it. However, when a business chooses to use what is a unique ID, the passport, as much as we love it, and it has our picture, or the driver's license is not a unique identification. Therefore, if businesses running their own private business choose to use the particular unique ID, isn't that also their choice?
May I just say, Minister Hill, Member Hill,
Yeah.
That is also an issue that persons who opt out will have to grapple with in their transactive dealings with others.
They will have to grapple with their choice. That's what you're saying. Is that a word?
Yes.
Yes. Thank you. Then that's clear for me. Thank you very much.
Okay.
Thank you for that.
Go ahead, Mr. Varus.
Yes, thank you for that question, Minister Hill and Mr. Chairman. Those 2 questions, and they lead to the points of concern which were raised.
Mr. Varus, may I just ask if you could speak a little slower, if you don't mind? Because of the technology, sometimes I think I'm not sure what's happening, but it seems to be going very fast from my end.
My apologies. I will make an effort to speak more slowly. Those issues, those questions that were raised by Minister Chuck and Minister Hill are at the center of the discussion within the Putiami decision, which was applied in our Robinson case, about de facto mandatoriness. It's important that things remain voluntary in practice as well as in law, and the letter of the law, and also the risk of commercial exploitation. So I'm very glad, Minister Hill, that you raised the issue of private sector organizations being able to mandate the use of NIDS. That is an issue. Yes, so I will continue.
Can I ask a question, Mr. Varus?
Certainly, Mr. Morgan.
Through the chair. So how does the government, based on your concern, in a free market environment, fetter the right of a business to organize their business how they feel like they want to organize it within the law? So if the business is not violating the law and they're using, just like they use the driver's license now and the passport, and they say, well, you need there's nothing that prevents them from saying you need two pieces of ID to do a transaction. How does the government tell a business that is functioning within the law that it should not function with the way it is functioning?
Thank you, Mr. Morgan. I'm glad you raised that point. It's within the law, right? Businesses must operate within the law, and if it is, that needs isn't to be mandatory. A business's decision to mandate the use of an NIC card, for instance, could find themselves in conflict with the law. Yes.
Does the court decision speak to private enterprise, or does it speak to the government and the ability of citizens to access government services and the ability of citizens to protect their privacy? Does the court speak about
it does, actually. It does. It does, in fact.
Does it say that if a business decides to use NIDS, then it could be violating the rights of citizens? Does it say that? I'm asking. I don't know.
Thank you for that question.
Mr. Morgan, just a minute, Mr. Barris. We're now going into the crux of the contentious nature of this new legislation. Just by way of reminder that the Charter operates both horizontally and vertically, citizen and state, and citizen to citizen.
Come on screen when they're speaking. Come on screen.
Okay.
Thank you for that. Thank you for that point, Madam AG, and also for that follow-up question, Minister Morgan. I will continue, but that is the central, a key issue that we're having, that are concerns about the application of the NIDS ruling. It seems to be the impression that as long as government entities do not explicitly mandate enrollment in NIDS.
Yes, she did.
Sorry, could you turn off your audio, please, Senator Hill? Continue, Ms. Tavares.
Yes, as long as government entities do not explicitly mandate enrollment in NIDS, compliance with Robinson judgment would be achieved. But we submit that this would be an incorrect application of the ruling, as this would transform NIDS from being purely voluntary to effectively mandatory, and would also result in function creep, which is what we're going to discuss next. Function creep, very important. Avoid function creep.
Okay. Mr. Chairman, can I just ask a question of Mr. Barris?
Sure.
Okay, so Mr. Barris, is it that you believe in the NIDS, you accept and that we need to have an ID in Jamaica that that is of a high level in terms of security and in terms of knowing that this is the person that you're dealing with? Do you accept that as something that is needed in this country?
Thank you for that question. I think what we're finding is that we're questioning the necessity of of the legislation as it's been envisioned. It appears to be conceptually challenging in light of the alternatives that we have found, for instance, in the UK context, that enabled.
Is it the UK private sector initiative? It's not a state initiative.
Actually, it began as a state initiative. We will discuss that in a bit, and look at creative ways that the government can utilize to engage in the digital economy without necessarily creating an NID system. So the slippery slope of function creep. India, function creep, as the committee knows, is the use of data collected for originally unintended purposes. India is currently witnessing a debate about whether a person's vaccination status may be linked to their Aadhaar number or a digital health ID. Singapore, which we have quoted as being a model to follow, has also seen a recent example of function creep in a different arena of technological regulation, which is contact tracing. We've had our challenges with that. At the beginning of the COVID-19 pandemic, I will speak a bit more slowly, the Singaporean government released a centralized digital contact tracing app called Trace Together, with repeated assurances to the public that the technology and the data collected would be limited for use during the pandemic. However, many months later, in December 2020, it was revealed that the personal data collected under the Trace Together app could be stored by the police for law enforcement purposes. Experience in India and Singapore should provide a cautionary example to the government of the importance of maintaining the trust of the people of Jamaica by restricting the use of NIDs for the limited purpose of authentication specified in NERA, and not to engage in any function creep in the future. Therefore, we were alarmed at a statement by government representatives at a meeting of the committee on January 5th of this year, that the aim of NIDS is also to reduce financial crime in Jamaica. We're also concerned about statements made by the Prime Minister at a sitting of Parliament on March 31st, 2020, regarding following the example of Singapore. Financial crime is not...
Mr. Barris, not to interrupt you, just to interrupt, yes. Through you, Chairman, have you looked at the objectives of the law?
Yes, I have.
Okay.
I have. Financial crime is very broad. It is very broad, and the purposes, the stated objectives of NERA are also very broad, and that is also an issue, as was discussed in the Potawatomi decision, which was applied in Robinson against the AG. Yes, so the majority.
You accept by way of observation and commentary that the courts have ruled in the most extreme of circumstances and have taken extreme dissenting positions in those cases?
I'm not sure I caught your question, Madam AG.
I'm saying if you have observed in your review and assessment of the cases, the very extreme positions taken by the court and of course adopted by our own court. In those
Still missed some of your question, but I think you are asking if I noticed the discussion within the judgments themselves and the different
extreme and dissenting position, the extreme and dissenting positions that have been taken.
Yes, I also noted that the dissenting opinion, the dissenting judgment of Justice Shanda Shroud was applied and affirmed by Chief Justice Sykes in the Robinson decision, which is important.
The most extreme positions.
Yes, which is
most
currently
extreme
law.
positions is what the Jamaican court has adopted.
Yes.
Yes. Right.
Right. And so to quote that section, the majority judgment in India struck down their...
And just to say that extreme positions always prove difficult in democracies, eh?
Yeah.
Democratic societies.
No, Mr. Barris, as I mentioned, Mr. Barris, we have gone through the bill. So just, as I said, just highlight the main points because there will be a short response to it and we're going to give you a detailed response later on.
Chairman, if I may say, if you don't mind, may we please let her finish the presentation, because I think this presentation is bringing into sharp focus the most contentious part of what we will have to grapple with.
Which
even
all of us
as difficult as it is to hear it, but we must hear it. Yes.
No, but if you go ahead, Mr. Barry, go ahead.
Yeah, Mr. Chairman. Mr. Chairman.
Yes,
I too would prefer that you don't rush Mr. Varys. I am keenly interested in hearing everything she has to say. I think they've done their research and they're highlighting their position very well, and I think they should be allowed to do so. This is, I think it is important.
But believe me, it is all in the paper that was circulated in our Member Bunting. Anyway, continue, Mr. Barnes.
I'm grateful. The issue of linking authentication with individual bank accounts. So the majority judgment, this is not the extreme position. This was not a dissenting judgment. This was the majority judgment in the Potawatomi decision held, shut down the measure for linking the digital identity card Aadhaar with bank accounts as being disproportionate, stating that under the garb of prevention of money laundering or black money, there cannot be such a sweeping provision which targets every resident of the country as a suspicious person. The presumption of criminality is treated as disproportionate and arbitrary. Nobody would keep black money in a bank account. They continued, and they said that the provision in its present form did not meet the test of proportionality. In checking for possible malice, there cannot be a mandatory provision for the linking of every bank account. They also noted that making the requirement of Aadhaar compulsory for all such persons or other persons that's in the banking sector in the name of checking money laundering is grossly disproportionate. There should have been a proper study about the methods adopted by persons who indulge in money laundering, the kinds of bank accounts which such persons maintain, and target those. As it was not done, and it was found to be disproportionate. So to the question raised by Minister Morgan earlier about private entities, particularly banks, utilizing or mandating the use of NIDs, and the NIC rather, they might find themselves in conflict with the law as it stands. The present specified purpose of NIDs under the legislation is authentication, and therefore we encourage, if it is that that NERA is to be implemented, that the function remain, its application remain restricted to its limited purpose, and that function will not be engaged in going forward. I'll just quote what Justice Sykes, Chief Justice Sykes mentioned in Robinson and the AG. He said the test of proportionality stipulates that the nature and extent of the state's interference with the exercise of the right must be proportionate to the goal it seeks to achieve. And as was mentioned earlier, we submit that the Data Protection Act must be operationalized first prior to the implementation of the NERA bill, its enactment. We noticed that the Data Protection Act provides a 2-year transitional period. However, we submit that if it is that NERA is going to be operationalized, the Data Protection Act must be operationalized first, but other speakers have mentioned this. Also, I'm not sure if I missed this slide, but we noticed that NERA will be fully evaluated when the regulations are made. If it is that we continue along this path, and therefore we submit that the drafting of the regulation should also occur with significant stakeholder consultation, just as is being done with the Act, which we're grateful for. Full transparency should also be maintained. The government should publish the cost of undertaking the entire NIDS exercise, including the expenses incurred in enrollment, the establishment and functioning of the authority, National Database Inspectorate, and the Appeals Tribunal, and other expenses. And this would help to foster trust amongst Jamaicans and give us a clearer picture to independently evaluate the cost and benefits of NIDS. And now let's look at the initial question that was asked: is NIDS the best way forward? As Dr. Thomas mentioned, and we're concerned that the government's decision to continue with NIDS, albeit in a reduced form after the decision in Robinson, is forcing it to create post facto justifications to build their case for NIDS. But are there alternatives to NIDS? We submit yes, there are alternatives, and these alternatives should be considered. Let's look at the UK example. So in the 2000s, the UK government developed a national identity register with associated national identity cards. The scheme used a unique identifier, and authentication was backed by biometrics. However, it was later abandoned for, among other reasons, the lack of an underlying framework and legal norms for identity, and importantly, the distrust of any government that attempts to organize the collection and use of such information. There was high citizen distrust. As a result, the more modest Gov UK Verify scheme was introduced, which was limited specifically to the management of online identity and transactions. It outsourced the verification of identity, giving citizens the choice of several private organizations with which to register. And some features of the Gov UK Verify scheme was that information was not stored in one place. There was no unnecessary sharing of information. The government department did not know or does not know which identity provider you choose, and all the identity providers had to meet government and international standards for security and data protection. There was also high transparency. So I think we should consider the UK's response to citizen distrust and apprehension to the organization and collection by their government in their proposed NIDS scheme. They didn't patronize their citizens. They didn't dismiss their concerns as being conspiracy theories or anti-progress. Rather, they responded to the concerns, the legitimate concerns of their citizens, and offered a new solution, which reflected their population's trust levels and risk appetite. The Gov UK Verify scheme is limited, as I mentioned, to the management of online identity and transactions. And if it is that the digital economy is what our leaders are eager for us to tap into, perhaps alternative solutions should be considered. As I mentioned, transparency and accountability remain a key feature of the program. The full costs are known, and improvements are underway and ongoing. Different pilots are being conducted now as they improve and change, with the government being open to feedback. Yes, the government, Gov UK Verify is part of the wider government Verify program, which aims to ensure that users can create and use and reuse digital identities across public and private sector services, which should be more cost effective in the long run, because there's no need for a new framework altogether. It should run alongside established structures seamlessly and eventually be self-funded. The example of Estonia is also very concerning. Of concern is holding up of Estonia by government officials as a model to follow. This is as Estonia's data security and privacy concerns are well documented. Additionally, the Estonian model is one we submit that would be incompatible with the Jamaican context. This is as Estonia's population is smaller, it's more homogeneous, it has a longer history of IT systems underpinning government operations, as well as, importantly, higher trust in the political and rule of law systems. And just as a general point of information, I can't help but notice that the trend in common law countries with strong histories of democracy is to avoid NID systems. Nations, however, with troubled histories with democracy and autocratic tendencies, or a history of greater state involvement or interference with citizens' rights and freedoms, tend to opt for NIDS systems. Estonia
but hold on, we have to look at that though in the context of the move to a digital society, because that statement taken out of context can certainly give the wrong impression, because I have looked at this research also.
Mm-hmm. Point is well observed, Madam AG. Our submission is that looking at we submit that the common law model to follow should be the UK. The UK took its citizens' concerns to heart, did not dismiss them, and instead of going ahead with the NIDS system, a creative solution was formulated to achieve engagement in the digital economy without the collection and storage of the large amount of citizen personal data. We submit that this is an option, just as the government threw out to the public the opportunity to come up with the architectural design for the new parliamentary building we submit that just as the UK has brilliant people, we have brilliant software developers in Jamaica who can come up with alternative systems to engage in the digital economy, just as the UK developed and is still in the process of developing and perfecting their Gov UK Verify system. Yes, we submit that there are alternatives that should be considered. The example of India and Estonia are examples that are cautionary to us. India, Dr. Thomas will later mention, has had massive data breaches. And instead of it being an example to follow, what began as being voluntary is now mandatory in effect. And court challenges are currently underway in India as citizens strive to maintain their democracy and freedoms. It's very, very difficult to do when NID systems are implemented. Yes. And now we'll just move briefly to some specific comments. Thank you for your time so far. As was mentioned by other presenters, Clause 10, we submit that in addition to the information specified under Clause 10.2b, the authority should also inform the individual about the nature of the recipients with which the information is intended to be shared during authentication and the details of the department or person in charge of operationalizing the access and purchase requests. This is just to ensure full disclosure is done. And at Clause 11, we submit that at the outset the law is unclear. Excuse me, I'm sure the persons have mentioned it, whether the identity information referred to in Clause 11 is required only for enrollment, or whether it will also be included on the NIC as a means of proving the individual's identity. And as other speakers have mentioned, we're requesting clarity on whether the biographic and biometric information will be stored locally on the NIC or separately at a centralized place. We submit as well that Clause 11.1a, in keeping with the comments of the public defender, appears to violate the collection limitation principle, which requires that the government collect only such data as is necessary and relevant for its stated purpose, and not to process the personal data for the purpose beyond the original identified purpose. And at the time of enrollment, there's a long list of information that the authority is empowered to collect, and we submit that many of these data points perhaps should not be collected in the first place. So consideration can be given to, in keeping with the comments of the public defender, reducing that list. And for the sake of clarity, we submit that Clause 11.1a can be amended to provide that biographic information shall never include race, religion, tribe, ethnicity, language, records of entitlement, income, or medical history. This we submit is very important. Clause 11.
Mr. Barris, that's now an extreme position that your recommendation is taking. We do understand that such issues have been used in the past, but there also there are guaranteed rights in respect of non-discrimination basis, and taking information is not tantamount to a discriminatory act.
Thank you for that comment, Madam AG. We submit that those comments are not extreme.
You say biographic information should never include No, but I'm saying free and democratic societies regularly take such information. I can understand about taking and use, because there are positive issues that attach information, not just negative ones. And if you're not able to disaggregate information about the composition of population, you may not even be able to serve them well and effectively in accordance with their rights too.
Thank you for that point. I think that's a fair comment. However, as is discussed in the Robinson judgment and the Putwami decision, the the issue of collecting vast amounts of data that can be utilized to create a 360 profile of a person that can later on be utilized for passive surveillance is very concerning. So we submit, these points of information are not presently included in the bill as it's worded, but we submit that going forward, this could be amended to state that the information collected will never include, that is to be retained on the NIC or by the authority within the card, records of entitlement, medical history, religion, ethnicity, etc. I think that's important, seeing that this legislation, if it is implemented, would be for posterity. And we have seen, as you well know, of instances where this kind of biographic information was included within national identification card systems, and it was exploited in the future.
Let me ask you something. How should the state respond to someone who say, I'm a black man subject to discrimination by virtue of my color, and all black youths are descendants of slave and stuff? Do you think that in the absence of information which would enable anyone who is treating with that complaint to assess veracity, you can be of meaningful assistance? And I mean, probably as simply and as ridiculously as I could.
No, thank you. I appreciate the point.
Someone who says, hold on, someone who says that I'm a Christian and I'm asserting my, if you don't know what they subscribe, just think about it. I think your submissions are worthy of consideration, and clearly you have done the work. And I think the biggest part of the concern, two things that the committee will have to grapple with from the concerns raised, is in relation to what it will truly mean, not only from a de facto perspective, I mean a de jure perspective legally, but practical de facto perspective of a voluntary system, and those who would have to establish their identity and use of it, and the other issue in relation to function creep. And that is why I asked you to take a look at the new objectives of the legislation, because another question that the state will also have to grapple with in a context where knowing the citizens in any free and democratic society, whether we can afford, given our economic circumstances, to establish systems that are costly for limited use only, when there are other areas that those systems can effectively assist with. And I take the point that things must not be done surreptitiously or under the guise, establish one aim and then there is a secretive aim underneath the surface. That point is well taken. But you would have seen the latest decision out of the European Court of Human Rights regarding vaccination and the administering of vaccinations in a society and principles like that. I think, sometimes we come to an issue from one perspective only, because that is the side we see without the other. But I want to say, you are at the end of your presentation? No?
Just about. But I would like to respond.
I want to know, does the Love March movement has a religious connection? Are you based? I just want to get a little better understanding.
Well, first, let me answer the initial question about whether it would be inappropriate it could amount to some unfairness if this type of biographic information is not included in the collection of points by NIRA.
No, I didn't say that. I didn't say that.
What were you saying? Can you repeat?
No. I'm asking, I say to you, be mindful that inclusion of certain information also has benefits, not just burden, not just prejudices. That's all I'm saying. Because people's sense of identity flow from many descriptors.
Yes.
Expect to be treated fairly many times in respect of established identification markers.
That point is well taken. However, we submit that those identification markers do not need to be included within the information collected by NIRA, by the authority, in order for them to be protected. We submit that.
And just summarize your reason for that again.
We submit that that would be overreach, that would violate the data minimization principle.
You say the same should apply in respect of taking information about the gender of someone in a context of gender fluidity and where persons are assuming different gender identities?
As I believe the Chief Parliamentary Council, as I believe the Chief Parliamentary Council mentioned, the issue, right, it's clearly defined male and female.
Yes, but we're talking about fairness. We're talking about fairness beyond the limited context. Yes, we know it's a thorny issue. I'm just asking because that is also a mark regularly collected.
Our submission, yes. I'm sorry for interrupting you. Right, the submission remains, Madam AG, that these points of information should not be collected. That is race, religion, tribe, ethnicity, language, records of entitlement, medical history, or income should not be collected.
Medical history, income, those are readily understood. But I mean, you're giving a laundry list, right?
Well, to be fair, AG, Madam AG, we had submitted earlier that the current list is a bit long. That is the laundry list. We are limiting the laundry list further by allowing it to remain specific. And
so
I believe that my submissions are in keeping with those made by the public defender and are in keeping with data privacy case law as to the data minimization collection principle. Yes.
Right. So tell me now, how is a national identification number viewed by your organization in respect of other numbers and numeric, what's the term? How is it?
Right, we do have a point on the number, which is I believe the point 2, but I would want to address facial image because it's under clause 11.
Right. Go address facial image. I'll come back to you with the kind permission of the chair.
Okay, thank you very much. As has been mentioned, clause 11(1)(b)(I)(1) facilitates the collection of a facial image as part of the biometric information of an individual. However, the law does not define facial image, leading to or apprehension and the apprehension of other presenters that it may relate to or subsequently include facial recognition technology. And the deployment of this type of technology has been severely criticized all over the world. You can look at footnote 45 of our written submission for greater detail, especially because of its disproportionate privacy impact on marginalized sections of society. So given that facial image seems to suggest something different from photographs, it is, as I believe some members of the committee may have intimated, that photograph is what is intended. We recommend that it be amended to substitute facial image with photograph explicitly. And as to storage offline, clause 11(1)(b)(2) states that the biometric information collected at the time of enrollment shall include fingerprints as defined by the Fingerprints Act. The NIDS Facts website states that there is no need to keep any biometric data online for NIDS to work. And at a Joint Select Committee meeting on January 5th of this year, certain proponents stated that the fingerprints will never be shared and will be stored offline. However, this is not currently provided for in the Act, and therefore we recommend that this policy position should be reflected in the proposed law. Let me move on to the issue of the decentralized nature of the database at clause 3C and clause 9. The database is a centralized database consisting of all the identity information collected by the authority and is to be stored in an encrypted form. However, we are concerned about the permanent and centralized storage of such sensitive personal identity information of every enrolled Jamaican. This raises serious privacy, surveillance, and security concerns, as I'm sure the committee well notes. the mere storage of such important personal data amounts to an interference with the right to privacy. And you can look at the European Court of Human Rights decision in S against Marpo. Also, so on that point, in contrast to other laws, such as those governing passports or even the electoral registration number, as the personal data under NERA is not stored in silos and it's expressly linked to other identity records of the individual, there are concerns related to security and also the concern of seeding. In the future, there's a fear that perhaps the government may use the NIN to link or seed all the identity records of an individual contained in various databases in order to create a 360-degree profile of a person, thus facilitating profiling and surveillance. This fear is exacerbated by the fact that the government has stated, some proponents have stated at different times, that some part, that even after a person seeks to cancel their enrollment and opt out of NIDS, some part of their biometric and biographic information will be retained. That was mentioned, I believe, at some town hall meetings and at a committee meeting. However, this is not reflected in the law presently. And in the Robinson decision, Chief Justice Sykes cited concerns regarding this. He said, in quoting Nancy Liu, that when this unique identification just from the biometric data is combined with a unique identification number and it's seeded into multiple databases, the use of that unique number is tracked. The biometric data not only allows individuals to be tracked, but creates a potential for the collection of individuals' information and its incorporation into a comprehensive profile. And Chief Justice Sykes noted with concern that NERA then proposed control over vast amounts of data, no opt-out, and linking the data held in different silos by a unique identification number, which reduced anonymity and increased the potential for profiling. And for those reasons, we believe that centralized storage may eventually lead to passive mass surveillance, particularly as we look at the storage of records in relation to authentication. Cancellation of enrollment and NIC at clause 14 and clause 20. Clause 14 we submit does not clarify what happens to personal data, especially biometric data, once an individual's enrollment is cancelled, and whether, if so, what type of personal data will be retained by the authority. We submit that the storage of this data will also need to comply with the Data Protection Act. And for clause 14.2, we submit that the individual should be given the right to be heard prior to cancellation of their NIC or enrollment in NIDS rather, in light of the severe civil consequences of cancellation. Presently, the law does not provide an individual with the right to be heard before cancellation takes place, only provides this afterwards. So we submit that the right to be heard should be given prior to the cancellation of enrollment and the cancellation of the NIC itself. Also, we notice clause 22 gives the authority unbridled discretion to cancel an NIC issued in error or if there's a defect in the form of the card, but these terms aren't defined. And so we submit that this term should be described. These terms should be described within the law itself or defined. And as I mentioned before, the right to be heard given. Also, in relation to clause 15, on the point of the NIC, again, we are
all right, let's focus on the boys right now, Minister Samuda. The data shows that the boys commit way more crime than girls. Our prison population is more skewed to men than women.
Minister Williams, you're on the wrong Zoom. Minister Williams, you're on the wrong Zoom. And your mic is open.
Can someone just mute her mic, please?
No. It just came out. From.
Please mute her mic.
Yes, nationally. Of course,
just
it
mute
differs
her
by
mic,
school.
whoever is the host.
Administrator, mute Minister Williams' mic. She's on another Zoom. Okay, Mr. Barris, trying to ruffle first, please.
Yes, I'm just about at the end now. Thank you so much. With NIN, the law isn't clear as to whether individuals can choose to enroll in the NID system only through the NIN or the NIC, or whether they need to enroll in both. So we're requesting some clarity, and also suggesting that clause 15.2a be amended so that it reads to the effect that the NIN shall be a randomly selected number that does not contain any digits that relate to an attribute or identifier of the enrolled individual. Not necessarily in those wording, but just to ensure that the NIN remains completely anonymous. So it shouldn't be that all lawyers, their number starts with 00 and doctors start with 05, or if you're from St. Catherine, you have 111 at the end of your NIN. It should be completely anonymous. And clause 16, the NIC, it states that 16.2 states that the NIC shall be a public document for the purposes of Section 22 of the Evidence Act, and clause 16.9 states that the NIC shall remain the property of the authority. However, given that the government has stated that a pattern of the individual's fingerprints will be stored on the NIC for authentication purposes, even though this isn't mentioned in the law presently, it is surprising that such sensitive personal data is not deemed confidential and the property of the individual. We submit that this may constitute a violation of the fundamental right to privacy and informational self-determination, as elaborated in detail by the Indian Supreme Court in Puttaswamy, which was quoted with approval in Robinson. Furthermore, the storage of a pattern of a person's fingerprints on the NIC for authentication purposes has certain security implications in terms of loss or theft of the NIC, and presently the law does not address the risk mitigation strategy in such a case. If this is to be put in the regulations, we request again that adequate stakeholder consultation be done, just as is being done presently. And coming to a close, clause 25.4 allows the authority to retain a record of each request for authentication or verification for a period of time that will be prescribed. The authentication and verification records of an individual will reveal every single request made by the authority, individual, or accredited third parties, and as such, it constitutes metadata.
Summarize, Susan, because you're reading from the script. You have been doing it all along, but I haven't stopped it.
Not quite. I've made some changes in my personal script, Minister Chuck, but I'm glad that you're following along and giving everyone an opportunity to read if you haven't had an opportunity. So the issue that we're having right here is that this authentication information constitutes metadata, which will provide a clear picture, detailed picture of the individual's activities. And as there's no time limit set presently on storage and archiving of this information, we submit that this raises security concerns and could violate storage limitation principles. And we also note that we didn't see a rationale behind long-term storage of the NIDS authentication or verification records, particularly in light of the fact that one of the purposes of NIDS will be to eliminate identity theft. We would like to remind that the storage of this information, the metadata, should also be subject to short timeframes to ensure the protection of personal data and the rights to privacy. And on to the lovely clause 4, clause 24, the disclosure of identity information and third party involvement. Let me go to clauses 17 and 25 first. The NIC is permitted to be used for proving one's identity as a means of facilitating voluntary, presumably transactions between the individual and any other party, And as mentioned earlier, the government has asserted that these types of transactions are outside of government regulation. But we submit that by outsourcing all responsibility in overseeing these private transactions, and by failing to even provide any procedural safeguards to regulate the actions of these private actors, and ensure that adequate grievance redressal mechanisms are in place, citizens' rights are at stake. It appears to be a very short-sighted approach because it ignores the unequal bargaining power between individuals and private corporations, and it sets the stage for commercial exploitation. And I'll just quote the Putwame decision, where Justice Sikri, the majority judgment, said, even if we presume that legislature did not intend so, the impact of the aforesaid features would be to enable commercial exploitation of an individual's biometric and demographic information by private entities. And that too would be on the basis of a contract between the individual and such a body, corporate or person, and this would impinge the right to privacy. And Justice Shonda Trude went on to say that allowing private entities to use Aadhaar numbers will lead to commercial exploitation of an individual's personal data without his or her consent, and could lead to individual profiling. They said that profiling could be used to predict the emergence of future choices and preferences of individuals. These preferences could also be used to influence the decision-making of the electorate, even in choosing candidates for electoral office. These are real issues that are being grappled with right now internationally. And this is contrary to privacy protection norms. Clause 24, disclosure of ID information. We noticed, Mr. Chairman, that you responded to the submissions of the PSOJ on this point. However, we have some additional queries. First one would be in relation to the retention of the ground of national security. But before that, just to go back to what you mentioned to the PSOJ, you said that clause 24(1)(c) would also be made subject to the order of a judge. However, this is not admittedly presently reflected in the legislation. And if these individuals would be non-police parties, what grounds would they have to apply for an order from the court? What would be the grounds? It couldn't be section 24(2), which is crime and interest of national security. So we're requesting some clarity on that in light of your comment. And on the issue of national security, the inclusion of this ground, we submit, potentially expands the scope for the misuse of the law and allow for profiling and surveillance by the state. The Supreme Court stated in the Robinson decision that the term national security was not defined in the legislation then, and it remains undefined now. It said the problem here is that there is a body of jurisprudence from India and elsewhere that suggests that national security issues are policy matters and not legal matters, and therefore are not justiciable. The inclusion then of the ground of national security, quoting Chief Justice Sykes, would be like a Trojan horse. This is because
but you know, this wouldn't be the first legislation that refer to policy concepts.
No. However,
and case law is replete with understanding of matters involving national security and defense of the realm.
That point is well taken, yes. Madam AG. However, I'm quoting verbatim.
I understand.
The decision of.
I understand. I understand, Mr. Barris. I understand.
Yes. Right. So it was stated that the inclusion of the ground of national security undefined would be like a Trojan horse, as this standard could be easily met and offers therefore no protection in reality. And he submitted that the discussion on national security highlighted that there was no real protection under the statute in relation to that ground. And we note with concern that this has been retained and no definition has been provided And so we just want to turn your attention to the discussion of the court in Robinson, where this was highlighted with concern and was found to be an issue. Yes, and just as I close, would like to say that particularly in relation to data breaches, Justice Sykes mentioned at the end of the, I don't know if it was at the end of the judgment, close to the end, or was it at paragraph 56? He said that all a determined hacker needs is one successful breach out of 1 million attempts. Thus, the stakes are very high, and failure to properly secure the data is not an option. In this type of scenario, it is not how many attempts were detected and deterred, but whether the risk of a successful attack has been reduced to no possibility of a successful attack. So we submit that as designed, tweaking NARA may be insufficient, as the legislation itself appears to be conceptually flawed. We submit that the government must be at pains to regain the trust of its citizens. And if this act would deepen the distrust, the question needs to be asked whether this course of action should be pursued, continue to be pursued in light of the alternatives that we discussed earlier. And finally, the structure of the authority. This was mentioned by others. There appears to be a conflict of interest.
It will be looked at as the structure.
Oh, I'm grateful. There we go. Then I'm at my end. I'll hand over to Dr. Thomas.
No,
Thank
but
you
that's
so
the
much.
end. That's the end of the presentation overall.
This is
right. So I want to thank you and Dr. Thomas for your presentation.
I think he wanted to make us a short comment, Dr. Thomas.
Yeah, man. In conclusion, there are general and specific recommendations. Is this the best way forward? We recognize that the number one issue, probably number 1 through to number 10 issue in Jamaica right now is crime. And we're really wondering, going up $1 billion plus interest in debt without any impact on crime is really the best way forward financially. But if we continue on this trajectory, certainly needs should be kept voluntary in practice. Okay, that there should be legislation that prevents function creep, and that function creep refers to, as was mentioned earlier, the importance of preventing the potential of profiling, commercial use, as well as other government ideas that may come up, whether related to vaccines, etc. And then also there's function creep that some are proposing that needs to be used to re-engineer our social fabric in terms of our understanding of gender and traditional marriage. That is also a function creep that we should oppose. We should learn from other experiences, the Indian experience, the Estonian experience. There's so much that we can learn from these other nations so that we don't have to go down the same route in terms of lawsuit after lawsuit. And so we have that benefit and really appreciate the ability, the privilege to be able to speak in the national consultation process, right? And then we are also asking again for continued consultation, especially through the regulations. That would be very important. Specifically, just want to highlight 3 things from the specific section. The importance of decentralization. Okay, you would find that this presentation would be awesome. Would be great when considering risk management. Decentralization, or rather, the centralization of the storage is probably one of the single greatest risks put forward so far. So we would advise that if possible, a creative solution for decentralization be put in place. And then, as was mentioned earlier, the Trojan horse remains, and then the conflict of interest. So we really appreciate your time and allowing us to be able to share this. And we encourage to look further, even in more detail at our oral submission, which goes even further. Thank you so much for your time.
Submission. Thank you so much.
Chairman, let me just pose a question to Dr. Thomas.
We have to finish up now. Yes, AG,
yes.
Go ahead.
Dr. Thomas, tell me something. Just share your perspective on the criticality of being able to identify persons and offenders in the fight against crime. Since you began your closing remarks, highlighting that as the number 1 challenge in the nation, and whether from your perspective and your organization's perspective, what is conceptually or fundamentally wrong in enabling the use of identification mechanisms, not only in enabling investigations that could lead to guilt, or as well as investigations that could lead to a suspect against whom evidence is not available. So it's not just guilt, but also in respect of innocence, not only the prejudicial effect, but probative value.
Right. Thank you so much for that question, Madam.
Since a society, we don't exist in a vacuum, and one of the hidden issues that seem to be coming up is a suspicion, especially on the use of identity information. I hear the submissions in relation to your perspective on what you've described broadly as conceptually flawed, highlighting things. Submissions with your consideration, not all of them I accept, but they do provoke thought. But since we do not exist in a vacuum, and as you rightly say, we as a nation are grappling with very serious issues. In particular, in the fight of crime, the capacity and the ability to identify, not to plant evidence on people, not to set up a case, but for legitimate purpose. What are your perspectives?
Right. Thank you so much for that.
Very quickly, please, Dr. Thomas.
Yeah, so crime is certainly our number one issue, and the international information regarding other nations and the use of their national identification systems to fight crime is probably negligible. So if the government is saying that they want to use...
Jamaica is almost unique in many things.
Okay. Right, but what the law has found, Madam AG, is that NIDS does not, in other contexts, reduce crime. It polices legitimate citizens.
No. I am not asking about reduction of crime at all. I'm asking about an aid. I'm asking your perspective on an aid. I might be very targeted.
As I'm saying, if the government...
It's not a broad brushed question.
If the government wishes to use AIDS as a crime fighting tool or a crime aid, whatever the wording would be, then it would be on the burden of the government to provide the actual data that supports that position. Currently, there's no data that we're aware of. So if there is data in that regard, that could be provided for a consultation process to continue.
Okay,
thank you so much. Thank you, Chairman.
Thank you very much, Dr. Thomas and Mr. Varus.
Thank you, Fabrice.
We're going to send you a written matrix response to many of the points, but we want to thank you for your presentation. Is 27 pages, which I'm sure the committee, I've read it, very interesting points. There's no doubt you've raised some points that the committee will need to consider, okay? So thanks again for your input and also for your oral presentation. And the response of the NIDS team will come to you by a written response. But at this time, we have Jamaicans for Justice who should have from 10 o'clock. So thanks again. So Jamaicans for Justice, are you there now? We want you to just finish up. Sorry to keep you waiting, Mr. Malcolm and Matthew. Okay, go ahead.
Yes.
We want you to just finish up the presentation you started.
Okay, I'll just start, Matthew.
Sure, go ahead.
Okay, thank you very much, Minister, and thank you for the time to continue the presentation. And so where we kind of had to stop abruptly on Tuesday, and so I want to set some ground as to, again, why we're here. For us, it's not the what, it's the how. And so as I said time and time again, there are many responses that are quite cogent that explain the policy intent, but we don't really see them in the act. And as such, we are really craving a dialogue today that provides us with clarity as to the legal footing for many of the reassurances that we keep getting, either from the statements in discussion or from the policy team. And a comment I wanted to start with on function creep, because it was an important discussion that happened just before we came on, which is that one of the ways that we protect against function creep is to conceptualize circumstances of that creep in the distant future even, and determine if the provisions of the law at present are sufficient to constrain that. And we think, in our view, the law right now has many opportunities for us to plug those gaps, and that's a lot of what our submission focuses on. Thirdly, on Tuesday, we explained a way to keep the authorities' ability to collect the menu options of identity information while addressing the concerns about its disproportionate scope. As a reminder, and it impacts our following point since we have this interruption between us, we propose restricting the discretion of the authority to mandate the full menu, which it presently has, and only empower it to mandate, if it ever comes to that information strictly required for establishing legal identity. The government themselves proposed only 4 attributes in April of 2020. And then finally on section 24, which continues to be a thorny issue, and again, it impacts the points coming from Matthew subsequently. So we clarified that, we agreed in that setting that sharing of data is certainly possible with third parties under section 24 in 3 particular ways. And what came out of that was that we propose that the court be involved in sharing of data under section 24.1.3, clause 24.1.3, with any other parties under any other laws. However, in relation to your response, Chair, you indicated that today and on Tuesday that would make sense to you and that it would be through a procedure just like what would happen with the police. However, while we appreciate the recognition that the court ought be involved in those unknown disclosures under any other law, it wouldn't be satisfactory to say it should just be like the police for 2 reasons. One, the procedure specified by the police is quite specific to national security, and so some of the grounds just wouldn't be applicable. But additionally, that presumes that the applications for that are all ex parte, and that wouldn't necessarily be optimal or appropriate for the wide range of things that could be disclosed to any other party under any other law, present or future. And so an importation of the procedure for police, which follows in section 24, would be reassuring but insufficient to address the broader concerns. In addition, we remind that our recommendations in section 24, which we won't restate after this, also included the right to establish a general right to know of disclosures under section 24 unless shielded by the court, which does not exist right now, though it has been said that it ought to exist. It only exists right now under section 25 as it relates to authentication. And then a comment on the Data Protection Act. And so we know the point, we've made it many times, it has to come before the NID is implemented. We're very clear on that and we're thankful for the concession there. However, we know that there is still concern about the 2-year exemption period, and we hope to get a very specific answer from the NIDS project team or the CPC or from the parliamentarians as to what will be done in respect of the 2-year period of non-application of the DPA, even if it were to come into place immediately. And then the DPA is thrown out oftentimes, which is very good law, it's thrown out oftentimes as sort of like the generalized response to any privacy concern that comes. And while the DPA does have very important provisions in place, the DPA is a general law that equally applies to a sole business, JPS, flow, a cook shop, a business, a school. And it doesn't always address the unique wants in society concerns that will come from NERA, which will not have a companion entity. So for example, the Data Protection Act only requires that one element of its first standard for data processing be met in order for processing to occur. So hypothetical in the Data Protection Act, NERA or any other data controller could process the data, which could include disclosure, analysis, or use, to exercise any function under any law, to exercise any function of a public nature, to pursue its own legitimate interests or its legal obligations, or if the minister exempts the data protection standards by an order which could apply to whole groups of persons and other categories of persons. And there are many more examples where the DPA, while very good in establishing broad standards, doesn't always plug all the scenarios that the potential of that data set as broad as NIDS could present, and Matthew will explain a few of those shortly. And so we just want to be very clear that when we make recommendations for specific incorporation in this bill to prevent those examples, it's with an understanding of what the DPA already prevents. And so to come back to where we ended on Tuesday, we were speaking about authentication and the need to have greater parameters around the processing and storage of authentication records. And I invite Matthew McNaughton, my co-convener of the Civil Society Coalition, to go into that presentation now.
Awesome.
Go ahead, Matthew.
Thanks, Chair. Thanks to the members of the committee for having us back again today. We'll just jump right into it. So I won't go through this position in its record in its entirety today, because obviously we've covered quite a bit. I think what I'll just highlight here from this is just a few important points. One, just a reminder to everyone, authentication is probably one of the most critical features of NIDS. It's the point at which you, myself, any enrolled individual is going to prove their identity to some other third party. So when a third party seeks to verify that identity, the NERA will create a data log. The law obligates the NERA to maintain a record of this information and keep this information on all of the individuals that are enrolled in the authority. With the broader adoption of NIDS, this data will increasingly capture patterns of behavior on enrolled individuals. And our position, in summary, is that the bill as drafted and the existing data protection law do not contemplate enough protections for this kind of data set. It's going to be fundamentally different and unique data set in the Jamaican context. We have to engage with it and its risks head on as we try to protect ourselves and future generations. So we'll just jump directly to the recommendations around this, because we've already covered kind of the risks and the issues on this. So our recommendations kind of start at the top. I won't read them out for you. I think the committee has the recommendations. I think the first one is that we should establish that the authentication and verification logs, generally that there is a prohibition against their processing, and that the information will only be processed in as much as it is necessary to provide enrolled individuals, yourself or myself, with their own information. I think the project team, others have mentioned the importance of individuals being able to know and control who has access to their information. And I think we want to retain that, but we want to generally put some safeguards and prohibitions on that information being used by many other authorities, whether in the private or public sphere. We should include some provisions that require the protection of this data and in similar ways to the ways that we're protecting the identity information. We've already spoken about the ways that this data itself can be, and other persons have now mentioned this, that this data can be used in a myriad of very dangerous ways. And so we want to make sure that this data is protected and explicitly obligated on the authority to protect it in a particular way, similar to the ways it referenced the identity information. And I think there's a point that may be said that, well, what if we anonymize the data or pseudonymize the data? I think we would posit, and one of our scenarios touches on this, that even being able to get the anonymous records for this information would allow a kind of profiling and targeting manipulation of the population, even with just using those anonymous records. I think that's important to establish clarification around. There are many recommendations here, so I won't go through all of them. We talked about prohibition from using that information. I think we want to make it clear with their section 25, and section 24 should be amended to state that these records or logs are the personal data of the enrolled individuals. The reality is that it may seem obvious, but it's not necessarily the case. One of kind of the biggest gray areas with data protection globally is whether logs are the personal data of the individuals that generate them based on interactions of services. There are ways in which logs can be stored that do not necessarily reach that threshold of personally identifiable information, but still could be used for the purposes that we're talking about before. So I think we need to include a proactive provision around this to make it very clear across the board, in addition to some of the other prohibitions on processing. I won't touch on the verification one. Another important one is that under section 25.4, it states that the authority has the discretion for how long these records are kept. I think we disagree with that. We think that should be something that is given to the individual. If I would like to delete or unenroll, remove my authentication logs, maybe and we'll touch on this a little bit later, I should have the agency to be able to do that. It shouldn't be the case that the authority alone can determine the length or the period for which the data is retained and or processed. Others have touched on accredited third parties. We think, I mean, the other one is around a public register of accredited third parties. That's not in the bill, though I suppose the project team could state that that will be in regulations. And then obviously on consent, which we won't touch on again for today. And then I think lastly, I think it's just very important, specifically as it relates to this, and this is a point that's been mentioned by multiple members in the coalition, by industry, that it's really critical that the project team and the government publish more technical documentation about how NIDS will function. We've heard from the project team that the business processes have been defined already. We know that some of those implementation decisions have already been made. But we talk about a number of other ID systems in other jurisdictions. Many of those published extensively white papers, flow diagrams, etc., about how their identification system was going to work before they even started implementing those things. And I think, to kind of build public confidence, to kind of engage the public and the expertise that exists in the public, in addition to the consultations that the project team has already started, we think these things should exist as public documents for industry and other persons to do that as well. So I'll pause there.
The DPA does have provisions that clearly allow data controllers to disclose information such as that where exemptions are provided. That may be okay in the general sense, but it would not be okay for NIDS. And so in the context here with this scenario, just to come back to it, as Matthew indicated, as you use your user ID card, especially in the future if the technology advances, data is generated, which includes your behavioral data. And so this scenario that is on the screen of the government using a potential future government, future political party, using the data available to improve public services to inform election campaigning strategy and messaging is a live issue and has been contended with in jurisprudence externally, as we heard from the previous presenter. And so this, however, is a risk of profiling, but it does not include a disclosure of personally identifiable information. And I want to explain why that's important. Because the Data Protection Act specifically allows for this type of information to be processed and disclosed so long as it doesn't personally identify persons. And so the Data Protection Act does not expressly prevent the type of mining of transaction logs, or at least an interpretation of the Data Protection Act is that it would not expressly prevent the type of mining of transaction logs to establish profiles for various purposes. And the Data Protection Act also expressly allows that if the purpose for this is research, which could be applied to any purpose, good or bad, then the particular provisions that would deal with disclosure
Let me ask
would
you,
not apply.
but Mr. Malcolm and Matthew, suppose the regulations say that the retention period should not be greater than 30 days. Would that assist you?
It would address the retention point, but it wouldn't address.
No, but if we put in the regulations, say in respect of 25(4), that the period should not exceed 30 days, or would that solve the problem?
So I'd want to reflect a little bit on that period of time, but your point is that if you keep a narrow enough window, then it wouldn't present the risk. That's your point, Minister?
That's the point.
Okay, so I would say that wouldn't solve the full issue. It would be a very good step. However, I want to recognize that because that data could still be disclosed within a 30-day period and then just analyzed by another actor who is not NERA. Because the disclosure would not be prevented. And so if somebody wanted someone wanted to really analyze this data for behavioral mining purposes and to establish profiles, and the only protection was that it wasn't kept for a long time, but there wasn't a prohibition on general processing analysis for profile forming or disclosure, as we have recommended in our many recommendations, then they would simply allow for a process of disclosing that, and then some other actor could analyze it. So it doesn't have to be that NERA mines the data and analyzes it, But so long as there is no safeguard against its disclosure or processing for that purpose, it is not very difficult to find crafty ways to process it. And then NERA kind of doesn't have to do it directly, which would be smart for NERA, but not really a protection for the data subject in full. And so that would be part of it. It would be good, but it wouldn't be fully sufficient. For us, obviously, we think what would be fully sufficient is for the set of things that we've recommended, because we've thought of multiple scenarios and we think that those would close as many of the gaps as we could creatively think about in these scenarios. I'm sure other actors could think of more. And we think those prohibitions are particularly important since there isn't a fallback fully. The Data Protection Act addressed that. One other way to address it would be to establish this broad prohibition and then introduce regulations that would deal with that, if it is that more time is needed to think about the particular parameters.
Just a point. Oh,
you would favor general prohibition, right? So in other words, in section 25, you would want say a section 25(8) that says that no information in regards to requests made by any individual, individually or combined, should be released by the NERA.
Yes, that would be one thing to include. The other thing to include would be including in the prohibition on disclosure in 24 all information, and putting under 25 that the only lawful purpose for which the authentication verification services can be used is for the establishment of a person's identity. That would make any other purpose tangential to identity services, which is the only reason why it's there, not a lawful use of that. Without that right now, the door is half ajar. And so that's what I would call a general prohibition. And then maybe even some of the other stuff that we've asked for could go in regulation so long as that basis is clear.
Okay, something to consider.
Thank you very much for that, Minister. So then moving on now to a very simple point, which is the safeguards of the privacy and design of the card. Section 19(1) enables the authority through regulations to add any information it sees fit to the card. Nothing is wrong generally with the ability to put things on the card. Maybe you want to put a reference number or you change how the logo looks or something like that. But we don't think it's appropriate for the authority to be able to add new identity information. During the January 5th session of the Joint Select Committee, NID's project team had indicated that it intended to have a partial fingerprint on the card, which is not presently in the bill. And so we think that the power to add new identity information to the card should require a revision of the law, because what goes on the card really is critical for privacy, but moreover represents effectively what information about the person is meant for public display, like your name probably, but what is not meant for public display, like an address or even the parish that you enrolled in. Maybe that could reveal information that someone may not want. Worse, if a full fingerprint pattern were to be put on the card. Again, not saying that these are the present intentions of the of the government, but this would be possible. A response could be that inclusion by the authority under section 19(1) would require an order subject to affirmative resolution. For us, that's not satisfactory. One, respectfully, we kind of know the process by which these orders get approved in Parliament. There's no real debate or ventilation or public notification. And the public who have enrolled would not really be required to consent to or know that new information is being displayed. To give a quick scenario on this, very simple, I'll just go to scenario B this time since we're out of time. A future administration may believe it's important to include person's address and occupation on the card because it's important to manage a population. That's somebody in 10 years' time. The authority then uses its power under section 19(1) to do this, and nobody is notified, and the public doesn't have to consent to it, though they enrolled under different terms. We think an easy fix to this in our recommendation is simply to remove the ability of the authority to require the display of other identity information not already listed in the Act through future regulations. To be clear again, this does not prevent the authority from adding other operational details to the card. And we will also suggest that the project team publish technical specifications on the current design options for the card. People are throwing out wild theories out there. Will it include your fingerprint? Will it be chipped? We don't know. Would be good to know so we understand what we're dealing with. So moving on, I hope that point is well understood. So we want to speak about the governance and accountability, and luckily this point was made several times. So we'll only focus on what really matters for us here. So You have indicated, Minister, that several times that the Joint Select Committee is reviewing the governance structure of the authority. I want to point out two observations. One, the present governance structure of the authority effectively makes it a regular government entity, and the NIDS policy said it was supposed to be under the OPM, which allows it effectively, like any government body, to be moved around the public service, reclassified, restructured, and otherwise have its affairs managed by a changing political directorate. But moreover, Section 7 gives the minister special power to give the board directives that they are required to adhere to. For quick reference, it requires that the minister after consultation with the chairperson, give the board directions of a general policy nature. Why is shielding the authority from this type of influence useful in managing risk? First, respectfully, there are just corruption concerns that have affected the highest levels of government. And for something as sensitive as this, we think it would be in the best interest to not have those concerns ever be raised as an issue. But third, second, if the established way is currently going to be proposed, the authority would be subject to all the things that come with running a regular government entity that's not a commission of parliament, for example, whether it is political appointment and interferences in the regular staff, administrative control, ministerial discretion, and the soft influence that comes from when you don't have an insulated body. So here's an example of this. Let's say we are a few years down the line. Right now, they're not processing transaction records. Let's say, for example, what we spoke about before doesn't happen, not because the law doesn't prevent it, but it's just not being done. And a private company is interested in getting access to the authentication logs of enrolled individuals in the NERA. Maybe a banking sector thinks that it should be processed. The authority is not yet processing this data, nor is giving access to public or private entities. And the management of the transaction log data is also not addressed in the law or the DPA, so there's nothing preventing it. Only the authority just doesn't do it. The company then approaches the minister with responsibility for NERA and proposes a fresh idea for data processing that could be valuable in their opinion to the government and to the economy. And they even give technical advice on how it could be done. Here's the impact here. Without forming a judgment on if that must or must not occur, under Section 27, the minister would be empowered to give the directive to the board that this should be a general policy pursued. We should start processing the transactional data. Just giving this as an example. I know we addressed that issue just a while ago that we don't want to do that. In this scenario, the NERA could also be pressured to process those transactional logs in a manner, even if it was anonymized, and it could even be something that could be monetized, as we have seen in other jurisdictions. And when we look to Kenya and India, those have actually been issues in their jurisdictions, subject of which have been litigation and law reform to prevent this type of thing, because they didn't want ministers to be able to do this. But moreover, under the bill, it's not clear what recourse the board would have if they were to hypothetically disagree with the directives of a minister. And so we have a few recommendations here that we think could address this. One, we think that the power of the minister to give directives to the board under Section 7 ought to be repealed respectfully. And this we make laws for good times and bad, and for actors we like and that we don't like. And so that's the nature of rule of law. And so no political actor, in our opinion, should be able to direct the manner in which the authority operates at their discretion. The board is already quite stacked with government appointees anyway. And second, we would establish the authority as a commission of parliament or some other independent body that is accountable to the board, inspectorate, and parliament only. We intentionally seek to avoid a vertical line of responsibility to central government in this regard, given the nature of the work that the NERA does. That is our recommendation. Moving on to position 10, which is a revision, we would hope, of what we think are some unreasonable formulations of the criminal offences. I know that the Joint Select Committee has intended and willingness to revisit the criminal offences. We're happy for that. We hope to give some specific ways that could be done. So the first criminal offence is sections 10.7 and 8, which is providing false information to the authority. Section 10.7 says it's an offence if a person gives, quote, false information or makes a false statement of a material nature with the intent of obstructing or misleading the authority when providing information, basically when enrolling or when making a modification or confirming something or obtaining the issue or reissue of an ID card. In general, that is sensible. It's in the specifics that we have a concern. Just to also clarify the offense, a person commits the offense if they knew or believed the information to be false, or they were reckless as to the veracity, the truth of the information. So while persons are encouraged to be truthful, here is the issue that we have right here. Not all information provided to the authority under section 10 and 11, the suite of attributes, are relevant to establishing a national identification, such as someone's occupation or their secondary address. And so we would suggest a nuancing here to say that in order to trigger the offense, the information provided has to actually undermine the authority's ability to establish identity. For example, the bill as worded could allow for criminal liability in circumstances where the person simply, for example, gave the wrong occupation because they were embarrassed that they were unemployed. Do we think that the authority is going to be hunting down persons who lied about their occupation? No. Do we think that the interpretation should ever arise that because someone gave the wrong spouse's name because they were married overseas and they're in a same-sex marriage and they're embarrassed to say so in Jamaica because they came here as a foreign worker, or that they're unemployed and they have an occupation and they say something or they lie by omission, that the offense is intended to address them? We don't think that's the intention here. We think the intention here is to prevent people from fraudulently obtaining identity information. And so we would narrow the offense, much in line with our first recommendation about narrowing the identity attributes to simply those that are material to establishing identity. The second offense that we have an issue with is the repeal. We would suggest actually a repeal or a major revision of the offense under section 1612 of failure to notify the authority if a card is lost, stolen, damaged, etc. So as you know, under section 1612, if a person without reasonable excuse fails to tell the authority that their card has been lost, stolen, damaged, mutilated, or destroyed, they've committed an offense. Respectfully, we think this is a little bit of a disproportionate use of the police powers of the state here, especially since this is a voluntary and optional system. If my card is damaged in a car accident and I just don't tell the authority, I will be deprived of my ability to use the card, but I shouldn't really be exposed to criminal liability. If my card is stolen in a violent crime against me and I just don't really tell the authority after a year, I just won't have the use of my card. I should not ever trigger a criminal offense. If my dog mutilated my card, it should never even raise the issue of criminal liability, only that the damage that flows to me is because I have failed to notify the authority, so I can't use the card. That's a fair and balanced way to say that adverse impact flows to the card holder. But to say that their failure to proactively tell the authority triggers criminal liability is a concern. And then finally on the offenses, that's it on the offenses. And then we move on to cancellation. So just to reiterate on the offenses though, the scenarios that we gave earlier about James and Mavis and Catherine here, who would have wanted to enroll for a NIDS, but in specific circumstances, and Tuesday we spoke about these, may have given information that could technically be deemed as misleading. James, for example, did not say he had a secondary address. And as you know, the bill requires both principal and other addresses and empowers the authority to require anything, including the other addresses. James could be subject to criminal liability. If you look at Mavis, the next example, who is unemployed but doesn't want to say so. So she says she's a domestic worker. She could not only not get her NIDS, which she wants to get, but she could also be exposed to criminal liability. And we take Catherine, who really doesn't really know what to do because she's a foreigner working in Jamaica for an international organization. She's married overseas to a woman in a country that recognizes same-sex marriage, not to get controversial here. And she doesn't really know what to do in NIDS. Jamaica doesn't recognize her marriage. We're not really going to talk about doing that for NIDS, but she decides not to disclose that information. Technically, she would have lied and misled the authority, and that could expose her to criminal liability. And so we would hope that these could be revisited to retool the offenses to make a more appropriate configuration of the state's use of its powers there and what really is intended to be captured by those offenses.
Just to say, through you, Chairman, Mr. Malcolm, just to say in respect of the example, your general point is taken, and I do accept the concern that in the drafting of any provision in a law, and more so for offenses, great care must be taken that we do not unwittingly cast the net wider than is intended. So that point is taken. But in respect of your provocative example, if in that specific case, providing the information would be of no moment because constitutionally such a union would be recognized. And I suppose such an explanation would have to make sense. It would have to
Well,
make
I understand.
I'm just saying.
Were you finished? Oh.
Yes.
Okay, thank you. Thank you for that. So your response to me there, Mrs. Maluhu Fort, is in relation to providing the information would have been of no moment because the union would not be recognized. That's fine, but the example has two options. One, she provides it and the union is not recognized. And we wanted to know what is the authority's intention there because she would have provided information. Would it be in the database or not in the database? That was the first example. The second example is that Catherine does not supply the information, thinking because the union is not going to be recognized, and therefore could be deemed by somebody else's interpretation to have misled the authority as to her marital status because the statute has not provided guidance on any of that, or has misled the authority that she doesn't have a spouse because the authority is empowered to require the name of the spouse. And so this is a matter that needs to more precisely be clarified under the enrollment section, but its impact by someone's interpretation, and we know when it comes to how offenses are interpreted, many times we've had situations where police interpret things far differently than prosecutors interpret things far differently than judges interpret things. And it is the risk of being caught in the net, which doesn't only exist at someone's actual conviction from the offense, but all of the risks that could come from the threat and from the triggering of the criminal justice process. We would recommend here that that interpretation not be able to arise in this provocative example or others. But I understand that you've taken the point generally. And so I'm
your
grateful.
point is taken, yes.
Matthew, is Cancellation you or me?
It's me.
Okay, all right, over to you.
Yeah, you can take a break. All right, we're coming to the end, Chair. We only have a couple more and then we'll be wrapping up and opening for discussion with the project team. So on this one, Chair, multiple submissions have touched on the topic of cancellation. We won't go into all of it. I think we want to make a note of a couple points. One, that there are two cancellation processes contemplated in the bill. Let me just go on. One that's contemplated and applicable to in section 14 for 1A and 2. In that case, the verb purged is used to describe what happens to the information of the enrolled individual. And then a second approach that relates to what I would categorize as general cancellations under subsection 1B, where the identity information is retained by the authority, but the enrolled individual loses the ability to use the card, and the authority retains the ability to process the information and disclose it in certain circumstances. So generally, and this is the section here that talks about the, section 14, subsection 5 talks about those two different verbs and how the information is used differently. I think our general preference would be for all enrolled individuals to be purged in cancellations, but we also acknowledge that retaining some information is necessary to prevent individuals from enrolling multiple times and receiving multiple national ID numbers. And I think that's a compelling case to be made by the state. However, we do not believe that the proposed cancellation process is sufficiently strong. And I think there are some easy ways to strengthen it. We actually propose that the bill establish under section 14 a right to erasure of all information that's non-essential to prevent duplicate entries into the national ID databases. As of now, it makes no distinction between the information that it retains generally versus information that is needed for this purpose. And so as we've already discussed, there's quite a bit of information that the authority will generate on the individual that is beyond the identity information that don't need to be retained when someone cancels their enrollment. And so we would actually propose that be as a new provision be added to the bill to enable the individual to a right to all of that information being removed. And I'll just present an example that just kind of illustrates that point. So we're going to take Claude. it's in the future again, the government announces some policy decision that enables broader data processing of information held by the Nero. Claude, like any other individual, may be uncomfortable with how his authentication records or his identity information might be processed and decides that he wants to cancel his enrollment. Based on the current draft of the bill, even if Claude were to cancel his enrollment, the authority would still be empowered to retain his identity information and his authentication records, as well as continue the processing. The continued processing of the authentication records is not prohibited by Section 14. The authority may also continue to process or disclose the authentication records, as well as Claude's identity information, which in many circumstances, even with the DPA in force. So our recommendation, or a couple of questions that we just want to ask to the project team, and then our recommendations as this, is whether is there an intention for the authority to continue processing non-identity information of enrolled individuals after they've canceled their enrollment?
Matthew, let me see, I will ask the team to respond to that directly. But
yes,
my understanding from previous discussion, once an individual cancels his registration, everything is removed from the database. In other words, no, but I'm just saying my understanding is removed from the database. But when he cancels, he has to bring back his ID card. Okay, so when he brings back his ID card, that will be retained so that in the event he returns to re-register, and he will get that NIN.
Got it. No, I think, Chair, I think that's a valid point. I mean, I think we should seek clarification on that. As the bill is worded currently, it makes a distinction. So if we look at the slide here, so subsection B2, so that's related to when someone cancels their enrollment, not subsection 1A or 2, which is, if I'm no longer ordinarily resident in Jamaica, or there's some misinformation, inaccurate information that was provided. So for most people, they're going to be under subsection 2 for that. And so all that subsection 2 currently states is that the authority shall not begin to cease to process that identity information provided by the individual. It makes no provision or obligation for the authority to purge the information, which is the verb that's used in the section above that, or to remove it at all. And in fact, it goes even further to say that the authority may still, in 14 subsection 8b, that the authority may actually continue to process or disclose the information as related to section 24, or as it relates to 24 IH under the Data Protection Act. So at least our read of it was that there's clearly going to be some information that's retained by the authority, even in the case of cancellation. And that information, that identity information could be disclosed even if I've canceled my enrollment.
That's not my understanding, but I'll ask the next team to clear it up. Okay.
Sure, Chair, absolutely. Yeah, so I think, the second question, and a number of persons have raised this, I think the general point is, in the first type of cancellation, the verb purge is used to describe the process. I think we just want to get clarification as to what is deleted and what's retained in that circumstance, as opposed to what is used in the second scenario. So our recommendations really flow from what we've shared before. I mean, that we reform the erasure process to also include all of the information that's non-essential for preventing duplicate registrations. I think that is a reasonable one. And that in the case of 3, an individual's enrollment has been canceled, there should be a limit placed on the authority's ability to process, disclose, and perform information verification services on the individual's identity that has been retained for deduplication purposes. And then for the first recommendation, just quickly on this one, is that in section 10.2, which is a section that relates to what information the authority has to communicate to the public about their enrollment in NERA when at the start of the enrollment process. We think it's important that the authority be required to expressly inform all persons that if they enroll in NIDS, there's no guarantee that their information will be deleted upon cancellation. So I think that would be a very transparent process for people to understand and make informed decisions about participation.
That's a good recommendation. I mean, to the extent that people will know that once you register, especially unique NIN, because when you cancel, you can't come back later on and ask for a new NIN, because that NIN will be unique to you.
Yeah.
And that NIN will be, it will now never be used again for anyone else. Okay. So that is a good recommendation that we should have a look at. Okay.
Thank you, Chair. All right. So, is there a question?
Before you just go back to the 14. I just have a additional point there, because Minister is saying he's not clear on why our position is the way it is. But if you know thank you. So just on this, Minister, I just want to be very clear that there are 3 conditions for cancellation. One.
Yeah, we understand.
Okay, but the conditions for the first 2, 1A and 2, right? So if you look to 14. No, you're right. Yeah, the 1A and 2, where you are no longer eligible, or where the authority cancels you because they need to cancel you because the information is wrong. That's where the highlighted word purged applies to. For 1B, that someone cancels on their own initiative, the only requirement is that the authority not begin or cease to process the identity information. So I would really want to understand. Because it's there, it's plain in our understanding. What would give rise to your interpretation that where someone cancels, the term purged applies across the board when the statute is only applying it to the bill is only applying it to 1A and 2. That's really important for us to understand. And if the project team could really explain how they would get that interpretation, I would be very grateful. And then second, separate and apart from the purging of identity information, the processing of transactional data, the authentication logs and the verification, is totally unaddressed. And so 14 would not prevent any future processing of that transactional information as well. And so it's really important that we distinguish between the purge in general and the application of the purge under 14.5, as well as the inclusion of the subject matter, which is more than identity information. Without that, then the purging and cancellation discussion would remain incomplete. So I'd be very grateful when the project team responds, if we could get an understanding and a clear answer as to how 14.5 would apply in those circumstances.
But we certainly have the response.
Okay, thanks. Is me again now, Matthew?
Yeah, man.
Okay, thanks. So I want to talk, this is quick now, we're almost wrapping up, supporting vulnerable persons in all service interactions. So we're very happy that the law right now provides some attention to the needs of persons with disabilities, and it allows for persons to apply for persons on behalf of children, incarcerated persons, and the mentally ill. But we think it could go a lot further. Section 5.7 requires that the authority, quote, have regard to the needs of persons with disabilities in the performance of its function. We think that could be improved in a few ways. One, it only mentions people with disabilities, but they're not the only group that would be deserving of special attention. And so that's one thing that we would suggest, that we actually expand this general mandate to people with disabilities to actually other vulnerable and socially excluded groups, given the functions such in so many areas of life, such as children, the elderly, illiterate persons, the homeless, non-English speakers, persons who are sick. Those kind of, so expand that general catch-all, having regard. The second is that having regard to persons with disabilities only is a little bit less progressive than where most accommodation language is going now. And we would propose the standard language that we would get even with Disabilities Act, which would be the obligation to make reasonable accommodation and perform other forms of support not just the people with disabilities and those other groups. So we would just expand, that's our recommendation on the general mandate. The second has to do with protecting the mentally ill. So section 10.4b of the bill allows someone to apply for enrollment of a person with a mental disorder within the meaning of the Mental Health Act if they are the nearest relative of that person. While this is good, it's important that recognize that having a mental disorder as defined in the Mental Health Act does not automatically render someone incapable of conducting their affairs or providing informed consent, which is really what the crux of the enrollment piece should rely on. And so for us, we would instead recommend that section 11.4b be amended to require that in circumstances where a person seeks to enroll a person with a mental disorder, that the person to be enrolled consents to the enrollment unless it has been demonstrated that they lack the capacity to consent or are unlikely to retain such capacity, and that the enrollment is in their best interest. Simply saying that you can apply if you are the next relative as defined by the Mental Health Act doesn't actually deal with the issue of if the person is capable of consenting. For example, people with bipolar disorder would have a mental disorder under the Mental Health Act. People with bipolar disorder on treatment, work in government, work in private sector, conduct their business quite fine. I know many of them. And so the law, as stated, just would need to be tweaked to address that. We would also recommend that section 11.4b, which also deals with mental disability, be amended to require that in circumstances where a person seeks to enroll a person with a mental disorder, that the authority be obligated to make a basic and reasonable inquiry into whether the person proposed to be enrolled has the capacity to consent, and only process the enrollment once it's satisfied that the enrollment is in the best interest of the person. This is also key to preventing people taking advantage of enrolling persons who are mentally ill and then once they're in control of them, using their ID and card to conduct business on their affairs because they're mentally unwell. This basic inquiry would be useful. As it relates to children, we're very happy that other people can apply for children. We would expand this in two ways, however. We would recommend that section 11.4a be expanded to include any person with lawful custody or care of a child, such as long-term foster parents. At present, what the bill says, it allows for a person in charge of a childcare facility to apply for enrollment on behalf of a child at the facility. But there are persons who wouldn't be operating a facility, like a foster parent, who maybe has a fit person order instead of and just that, not running a facility, who would be equally in such a circumstance. The Children Advocate also raised the issue of children in conflict with the law and recommended the facility manager. Additionally, however, as a safeguard there, because children in childcare facilities are broad, they could be there for 2 weeks, they could be there on a place of safety and not in a fit person order, in which case parental rights have not really been transferred. So we'd amend section 11.4a to limit the power of managers of childcare facilities and any other person who isn't a parent or guardian to enroll a child to only circumstances where parental rights have been severed, or a child is in long-term state care through a legal instrument like a fit person order. Again, children in Jamaica stay in places of safety for years sometimes without having parental rights transferred. Further, where such applications are to be made, the bill should require notification of the parent or guardians where they are still living and allow for any reasonable period of response prior to processing the enrollment. That's just an important safeguard. And so we think those 5 recommendations taken together, the general mandate, the 2 on mentally ill persons, and the 2 on children, would help provide a more complete support for different categories of persons who are in need of special assistance. Recommendations 13, making appeals process more accessible. This is focusing on 2 issues. One is a technical issue, which is the definition of an appellant. So section 26.2 states that the appellant must be an enrolled individual if they were to apply for any decision, but the tribunal has jurisdiction over any decision the authority makes. Under section 2, an enrolled individual is defined as an individual whose identity information is stored in the national identification databases. So you have to have your information stored to be an enrolled individual, and to be an appellant, you have to be an enrolled individual. This, however, creates a kind of a technical challenge in which the current definition of an appellant would not include an individual who is denied enrollment and who wants to appeal in a strict sense of how the Section 2 and 26.2 are worded, and who wishes to appeal that decision. We think this is mainly an error, and we don't think that's your intention, because in Sections 10 and 14, you clearly allow for decisions related to enrollment to be challenged. And so it's simply about the technical precision of the definition of the word appellant, which seems to be in conflict with Sections 10 and 14, which contemplate an unenrolled person also being able to appeal. So that would just need to be tweaked. And we would also look at the time allowed for appeal. So there's a 28-day period allowed for appeals under the Act. We think it's short compared to both the general understanding of how government works, but also other appeal processes in other legislations. We look at like a 90-day appeal period in the Access to Information Act, for example. And so we think that it's likely that when people have issues with the authority, they're going to first attempt to resolve the issue by contacting the authority instead of immediately appealing it. But the time starts running from the date of the decision. So that process of corresponding with government is not normally quick. It could be that it takes a month to go back and forth. They may even appeal the inspectorate first and complain. And all of that time, 28 days would have been gone. Now, we think that there's really no need to constrain appeals to 28 days. And while the bill does grant the tribunal some discretionary power to extend the period in which an application appeal may be lodged, that's totally at their discretion. And the underlying issue is that the short window doesn't need to be that short. And so we would recommend expanding that. And then finally, this is an interesting one. The appeals tribunal's power to regulate its own proceedings is normally a power we give to tribunals. In the second schedule, particularly Section 9, the appeals tribunal has this broad power to regulate its own proceedings. And that includes how maybe evidence may be supplied, how arguments are given, notices are served, that kind of stuff. We are concerned, however, that in a circumstance like this, which could deal with if someone gets an ID or not gets an ID, how the information is used and other sensitivities, that regulations would be a better place to outline the operational procedures for the tribunal. Right now, delegating that power to the tribunal entirely, which could change its rules of procedure with each new tribunal, is not, in our opinion, an appropriate way to delegate that authority given the decision-making power of this tribunal and the degree to which the decisions may impact persons' ability to participate in society in full. And so we think those three recommendations, again, the definitions of an appellant, the time period for an appeal, which we think should be at least 90 days, and the delegated power to regulate the affairs of the tribunal would help improve the tribunal's transparency, accountability, and the degree to which it satisfies the types of oversight we think it ought to. And with that, over 2 days, we are grateful for the time to present these core positions, and we look forward to hearing the responses and engaging with them as well. Thanks again for your attention.
Yeah, Roger, I want to thank you very much, yourself and Matthew, for the very extensive assessment of the bill. I had the opportunity to look at your written submissions and also to let you know that, in fact, a comprehensive response has been prepared by the NIDS team to your submission, which will also be sent to you. So I'm going to ask the NIDS team now to respond. Go ahead, Camila.
Good afternoon, Minister. We will try our best to respond in a timely manner. However, initially, we must note that having only received this document, which went a little bit differently from the previous submission, we were not able to complete all the slides. However, we will still try to respond as best as possible, utilizing what we have before us. Just 2 points before we go on. We noted the indication that JFJ was aware of what is in the DPA, and therefore it appeared that we would not, any response with regard to that would not be sufficient. However, I believe it's important to indicate to Jamaica, to the committee, that the DPA, the Data Protection Act, will be, for want of a better word or phrase, the supreme law governing data privacy and protection, notwithstanding the type of data that you are utilizing or processing, it will still be the supreme piece of legislation, and that the Information Commissioner has been given the authority to do certain things to ensure that any type of institution will be able to be in line with that particular piece of legislation. That's why the register is there, where you will have to indicate the type of information, data that you'll be processing. That's why data impact assessments are part of the legislation. Additionally, it was stated at the last meeting that we indicated that data sharing would, right, as you were speaking about, or rather as JFJ was speaking about clause 24, the concept of data sharing and my response to same was indicated in regards to clause 24. Now, I had responded as it relates to data sharing previously. However, that was as it's related to data sharing only with regard to that respect, not data sharing just willy-nilly. It's just data sharing for particular instances and only with the consent of the individual, the enrolled individual, unless of course the carve-outs in on clause 24 or section 24 of the Data Protection Act and any other carve-out that may exist in any law or within Data Protection Act would apply. All right, so let us start. Now, with regard to, we're gonna go consecutively as usual. So section 1, you had indicated that you—
Somebody has their audio open though. Just turn off your audio, whoever is not on, to avoid the distraction. Sir Kamika, go ahead.
Okay, sir. All right. So clause 1. So JFJ had indicated that they wanted the bill to be amended to require the DPAs to be in place. So that's an administrative decision. That wouldn't be something that would be necessarily encapsulated in legislation. That would be, so that is a matter that we refer to the committee. Right. You would like or rather the JFJ, pardon me, through you, Chair, the JFJ would appreciate the bill's current definition of identity information to only be the information necessary to creating or proving a legal identity. Our response to that is that the existing definition captures the policy intent of the bill. Reference is also made to our response, which we will give below, outlining the rationale for collection of the different data attributes. JFJ also recommended that the objects of the bill be amended to include explicit reference to promoting and protecting the human rights and fundamental freedoms of persons in the society. That is already within the Constitution. However, we refer that to the committee as to whether or not they believe that that object should be included. Secondly, or rather, with regard to the objects, the JFJ also recommended that an object be included to indicate that the bill rather, would be to facilitate access to legal identification. What we have indicated is that the committee may wish to consider incorporating language into the bill to note that the bill seeks to facilitate the recognition and protection of the legal identity of an individual.
What does legal identification, let me get an understanding, what is the coalition's concept of legal identification?
That's a hard one. I think it is a form of recognizing a person as a unique individual that is authorized by the government as therefore being valid. It is what opens the NIDS policy 2020 as identity as a human right. Those are the words. And the basis that has been said in the NIDS documentation from before, that the purpose of this bill is to facilitate increased access to legitimate forms of identification, which we support. The only request here is that that does not find its way as an express object in the bill. And given that that has been repeated multiple times as the purpose of this bill, we think it would be useful to include it in the objects. And I think the projects team is effectively saying that the committee could consider that as well. As not being contentious. If I understood you correctly, Ms. Spacey.
Right, not necessarily access to legal identification, but recognition and protection of legal identity. Right.
No problem.
Okay, as it relates to clause 5, you had indicated several, through you to the coalition, several areas within clause 5 that the coalition was suggesting amendments. So clause 5, 3, and 4 to amend the functions and powers of the authority to include the observation of human rights again, which you had already referred to in the objects.
The disturbance is there again. Is it yours?
It may be me, Minister. It's quite right. Yes, it is me. I'm so sorry.
A fan or something.
Yes, unfortunately, I'm in a windowless room, but I will.
All right,
I will persevere. All right. So establish the authority as a commission of parliament, which the committee has already addressed. With regard to the observation of human rights and fundamental freedoms, similarly to the objects, we will refer that to the committee. With regard to a new section be established to mandate that the authority have due regard to the circumstances and needs of vulnerable groups in executing its functions and make reasonable accommodation and provide special assistance at all stages of their interactions with the authority. Notwithstanding the reference to the Disabilities Act, we will refer this to the committee as well, whether or not the placement within the objects is the best placement is something for consideration. Now, this one was one of the new issues that we were able to go through from your presentation. And this was a question, given that the NIDS project team has publicly stated the objective to operationalize NERO sufficiently to have the capacity to issue cards by September. How are they configuring the system for data processing without knowing the requirements to be included in the Data Protection Act's regulations? All right, so firstly, let's make it clear that the comment was made within the context and with the condition and understanding that the appropriate legislative framework would be in place. I believe it was actually, if it was stated something to the effect that once the appropriate legislative framework is in place, cards could be rolled out in September, or words to that nature. Now, the solution is configurable and responsive to process changes. So we'll be able to meet the requirements of these data protection. The solution itself will be able to meet the requirements of data protection and privacy rules. It's important to approach systems implementation, we believe, in this manner in order to adopt future improvements and to be able to easily make the modifications. So it's anticipated that once the regulations are in place, further assessment would be done and the necessary configurations applied to ensure that the solution is in compliance with the applicable laws and regulations, and that's before the NIDS is piloted. Now, the outcome of the pilot of the NIDS is likely to inform further changes that are not yet known before full rollout. And so even after full rollout, there will be a life cycle for continuous improvement of the system, as well as continuous monitoring for compliance with the DPA and the relevant laws by the board, the inspectorate, and the authority itself. As it relates to the ministerial directions, you had, I'm sorry, when I say you, the coalition had indicated, or rather had suggested that the power of the minister to give directives to the board be repealed, as no political actor should be able to direct the manner in which the authority operates. So we have indicated that the committee has indicated that it's going to be revisited the governance structure and oversight framework in the bill. But we believe it's important to note that these are general directives, directions of a general character that are related to policy. And just to remind Jamaica and the committee and everyone here and watching that constitutionally policy is within the purview of the cabinet. And that is why the minister may be able to give directions of a general character about the policy of a government or public body, because they will be the ones implementing the overall policy. As it relates to the national databases, now, you had indicated that the Act should place limitations on the kind of data that could be shared and accessed across multiple platforms linked to the unique identifier. Now, this is already encapsulated in the bill as far as we are concerned in the different sections or clauses. And also, this bill has to be considered, within the framework of the Data Protection Act, which limits processing and disclosure to the minimum necessary for the purpose for which the data was collected. And as I indicated, we'll go down, when we reach to the appropriate section, we'll indicate different attributes and why we think those are necessary. Now, section 10.2, you hadn't indicated this in your presentation. I don't know if it is you are withdrawing that. You were saying that it should be amended to require that the authority, oh no, you had indicated this, right? So section 10.2 should be amended to require that the authority expressly inform all persons upon enrollment that there is no guarantee that their information will be deleted upon cancellation. And the committee, we believe the committee may wish to consider this recommendation as it will lead to informed consent or a greater level of informed consent to round out that area. With regard to enrollment, you were indicating that in order to trigger, okay, this is with regard to the offense of committing a criminal offense if a person provides false information or makes a false statement of a material nature with the intention of obstructing or misleading the authority when they're giving the authority the information for particular purposes. And then you also looked at several scenarios. Sorry, it's just that I am now trying to put them in. Right. So you also looked at scenario 2 with James and 3 with Mavis, I believe. And then there was 4 with Sarah and her wife from overseas. Okay, as it relates to, right. And you also agreed that you doubted that the legislation would be utilized as a, for want of a better word, a hammer for particular persons. In our view or understanding of that section is that the obstruction or misleading by the applicant would be so egregious that it would go towards the functioning of the authority. So it would impact on the functions of the authority, on the authority being able to discharge its functions in such a manner. None of these cases that have been highlighted would do that. So your recommendation was you needed to, in order to trigger the offense, the bill should require that the information provided has demonstrably undermined the authority, right? And we agree that information would need to be proved in court in order to establish that that the offense was actually committed. However, even to bring it to charge would, of course, require some reasonableness, and we don't believe that this is a reasonable interpretation of that particular clause, nor do we believe that it would be interpreted in that manner. Okay, now you also went on to say that the bill should explicitly limit the offense to only identity information required to establish a person's identity and exclude decisions not to disclose non-essential information. Okay, so with regard to this particular response, it has to be linked with what we don't agree that any of the information provided is really non-essential, in keeping with the tenets of legal identity as a human right. It is also necessary to protect that unique legal identity. And one of the ways to do that is to ensure, well, first of all, to establish that the person is indeed unique, is to utilize as much information as you can, while still ensuring that you are not stepping over the minimization rule, right? And we believe that the data set that has been put into the bill, which by the way, may be required. So, it's not going to be necessary in all cases or required in all cases. And that's why the discretion is given to the authority to indicate sufficiency, or rather to determine sufficiency is necessary to be able to, one, ensure that this person, or be able to say to someone that you may recognize this person as Roger Malcolm, who is sitting here before me, versus Roger Malcolm, who is somewhere else in Jamaica, lives somewhere else, married to somebody or not married, etc. Right? Okay, so perhaps I should go to the two scenarios then. So James lives in Balaclava, right? You're saying then, so his basis for registering with the needs is he needs an ID to qualify for the summer work program. And he lists his town address because he thought it would look better on his job application. The authority has required that all addresses be included in applications. The authority has required, or rather may require, that all addresses be included. Now, reference is made to clause 11.2b, right? Now the application, so you also went on to say that the impact is that when they verified James' address, the authority learns he didn't disclose his address in St. Elizabeth and therefore denied his application for lack of accuracy. Okay, now reference is made to clause 11.2b. An application for enrollment may only be denied under the bill where it is found that the information submitted was not sufficient for enrollment. Now, the inaccuracy of the information provided, simpliciter, is not a basis for denial of the application. The verification process may very well result in highlighting several inaccuracies. And so the authority would indicate that to the applicant who may or may not decide to provide correct information or additional information. However, once an accurate principal address has been provided, that information would be deemed sufficient to satisfy the address requirement for the basis of enrollment. So he would not be prevented from enrolling on that basis, right? So now let's look at the elements. You also indicated that James is told that he's misled the authority and could be charged with an offense because he didn't list both the grandma's name and his address in Balaclava, and could be subject to a fine up to $3 million. Now, the elements of the offense are established where the applicant would have provided misleading information with the intent to obstruct or mislead the authority to carry out its functions. We don't believe that Jack has demonstrated this intention beyond a reasonable doubt in this instance, right? And it's important to note, though, we're not condoning ever the providing identity information that is not accurate, because the provision of accurate and fulsome information serves to better enable the authority to protect the identity information of the enrolled individual, and also to ensure that the legal identity of the person that is being recognized is a unique, strong legal identity. And the provision of inaccurate information will therefore damage the integrity of the system, and it would also serve to facilitate identity theft and fraud, which helps no one. As it relates to your scenario 2, Mavis, I believe, indicated she was unemployed. No, I'm sorry, Mavis indicated that she was a domestic worker when she was really unemployed. Occupation, however, doesn't refer to employment status. So in that instance, she would be well within her right to put domestic worker instead of unemployment. In any event, again, we don't believe that that is a situation that would rise to even sending anything to the DPP requesting that this person be charged. I'm trying to ensure I am going through everything.
Well, put it another way, Jamaica.
Yes.
Roger and Matthew, the NITS team have prepared a 28-page response. So Kamika is highlighting
Thus far.
some of them. So, and what is more to Matthew and Ronjay, because of the additional material you brought in the oral presentation, I will ask Kamika, as she indicated, to probably add, you know, one or two, just as she's doing now, highlighting some of the issues that were not raised in your written presentation. So I think, I don't know, Kamika, if there are any other points you'd like to raise now, feeling send the written response to them.
All right. There were some pressing issues, I believe, that they
Go ahead,
had.
go ahead.
The
No, go ahead.
sufficiency of who should go ahead, Minister?
You.
Okay, right. So they had certain questions that they had asked.
Sure.
So for instance, it was asked, is it the position of the government or JSC members that the authority should be empowered to deny individuals access to legal identification based on a failure or unwillingness to provide identity information? And to that, the response is that no, that's not the policy intent and is not reflective of the provisions of the bill. What was the government's rationale in departing from principles and data collection scope it's outlined in the policy document informing the drafting of the NERA bill? There hasn't been a departure from the principles of data collection outlined in the policy. We believe that the data set outlined in the bill remains adequate, relevant, and limited to what is needed for the purposes for which the data is being processed. It's important to note that address and marital status formed a part of the required biographic information that was stated in the policy. And to give you examples of the attributes, the names of the mother and father would be critical, particularly for minor applicants. The name of the spouse will flow from marital status, and you'll note even when you're applying for a passport, you are required to provide that information. Nationality, country, place of birth, critical to determine the eligibility of the applicant. What was the right? Also, policy is not fixed. It may change during the legislative process, even as it's illustrated here in our current exercise. Discussions with stakeholders served to highlight data gaps that were not addressed by the policy as indicated, as published. It was determined that the data attributes outlined in the bill are necessary in order to ensure that the information that is provided only once, and that it will allow for the recognition of a unique legal identity, a strong, unique legal identity. And also, it was to assist Jamaicans who are without the resources to access the formal financial system to be able to satisfy KYC requirements without more. So JFJ has, and the coalition, has indicated a suggestion for a value-added system. And we appreciate that. It would, of course, add funding to the government's coffers and hopefully to ours as a result, generally as citizens. However, it is a policy intent for financial inclusion, and it is not thought necessary or in the best interest of anyone to require persons who are already not financially included, who are already not a part of the formal financial sector, and as a result, unable to access certain things for themselves, to require them to then have to pay extra to be able to obtain this particular level of access, which is what the value, from what we understand, the value-based suggestion would end up doing. Okay, as it relates to amending the bill, right? So the JFJ and the coalition also indicated that they believe the bill should be amended to clarify the authority's discretion under 11.2, and it should clearly state that once an individual provides sufficient information to establish their identity, the authority cannot deny their enrollment. In our estimation, that is what it states. However, this is appears to be a drafting issue, and so we would refer that to the CPC. Section 11.4 spoke to the custody and care of a child, and that issue was raised before by BOJ, and also the committee was advised by that time by the CPC that the bill effectively states what you are actually requesting. All right, as it relates, oh, I'm sorry, I forgot to do the contentious, what was it? The provocative, I believe, scenario. Now, in both cases, the ladies would not fall into the category of misleading or obstructing the authority, because in instance one, the authority is subject to the Constitution of Jamaica. Spouse, as defined in some legislation, it's either you're married, man and woman, or male and female, or you're living with a male as a female or a female as a male, as in a manner similar to man and wife, or wife, I'm sorry, woman and husband. Accordingly, there would not be she would be well within her right not to indicate spouse. Should she indicate spouse, we would have to, the authority indicate that that would not be possible to enter into the system, because that is not a concept that is recognized under Jamaican law. Because it is not a concept recognized under Jamaican law, for her to, she is therefore single, as is, what's it, Sarah and Catherine, I don't remember their names. They're both essentially single. And that is, so her putting single on the application would also not be misleading the authority. Okay. I don't know if there is any, oh, the mental disorder. All right, you had indicated that you wanted to amend to require that in circumstances, the person must demonstrate, the person to be enrolled, it must be demonstrated that the person lacks the capacity to consent. And you had gone on to indicate that in your understanding, mental disorder under the Mental Health Act doesn't covers persons who may just have, for instance, bipolar disorder. They may still be able to make decisions, etc. However, a reading of the Mental Health Act indicates that mental disorder means a substantial disorder of thought, perception, orientation, or memory, which grossly impairs a person's behavior, judgment, or capacity to recognize reality, or ability to meet the demands of life, which renders a person to be of unsound mind, or mental retardation, where such a condition is associated with abnormally aggressive or seriously irresponsible behavior. So we don't believe that in any of those cases, it would be possible for the person to give consent. What we do note, however, we noted it was not, this is not the first submission that noted it, that persons may be taken advantage of. And consequently, we had indicated to the committee, or suggested to the committee, that this could be considered for a different approach to be considered. And in my research, I have seen in the Fingerprints Act in a particular instance where a medical certificate is utilized instead of a court process, which would serve to disenfranchise way too many persons who may wish to be enrolled. So we put that to the committee for its consideration. Is there any part, there's so much, I don't know. What is it that you would wish me to address? 14?
Well, I think, so, I mean, without responding, we have response, but without responding, it would be really useful to hear your interpretation of our positions as it relates to the risks, particularly in the future, on the transactional logs.
Okay. As it relates to the transactional logs, now our understanding is, yes, there are still questions under even the GDPR as to what a transactional log is and how it can be protected under DPA or GDPR as it is in that instance. Now, in my research, however, there was an overwhelming tendency towards whatever is in the transactional log that relates to personal data makes transactional logs now become a part of the treatment that is meted out to instances of personal data. And as a result of that, we believe that that would indeed fall under the authority, in that the authority would be required to treat those logs in the same manner as identity information, which is a subset in our estimation of personal data. As it relates to your concern now under clause 24 about the identity information not being mentioned, I'm sorry, all information not being mentioned. well, not only, well, you had just said
yeah, all
change it to
information.
right?
Mm.
If you look at clause 30, well, firstly, the bill does indicate in several instances that information, not just identity information, but information must be treated in accordance with the principles of the Data Protection Act. Secondly, the secrecy and confidentiality duty is extended to all information, not just identity information. It isn't appropriate, we believe, to indicate information within clause 24 because clause 24 only speaks to identity information, and because information is referred to generally elsewhere, we believe it is appropriately covered. There was something else.
Could I just press you on that point specifically though? I mean, I've responded on the others, but we can talk about those later. But the transaction logs, so you started with the premise. Yeah, you start, yeah. So you started with the premise that it's kind of unclear right now. Is that an accurate statement? Like in terms of the incorporation of transaction logs right now as a matter of DPA, you've given how you think it would be treated, but would it be safe to say it's not fully resolved at present?
Well, nothing in law is fully resolved ever.
I know, Miss Facey, but okay.
But what I can say is that from my understanding, transactional logs would still be information that we have to protect. And once it can be linked to anybody, it will be personal data. So we would have to remove all the attributes before we can process it for any other reason. We can't disclose transactional logs at this point in time under the bill that is before you. We can only disclose identity information as defined in the bill. And we can't disclose transactional logs as being a part of any other type of information unless without running into the duty that is under clause 30.
Okay, so a few things there. So you said you can't disclose any other information apart from identity information. Though the bill doesn't prohibit it, you don't want to put the prohibition in 24 because that speaks to identity information.
I said the bill does.
Oh, I just thought you said you can't disclose transactional information under the bill because it would, in your estimation, be prevented by the Data Protection Act, even though it's not specifically prohibited.
No, it's also specifically prohibited under clause 30 of this.
On 30, but isn't 30 the obligation to secrecy and confidentiality?
And therefore we
for
can't
information
disclose.
Once disclosed. No, but therefore it's hold on. Okay, let me just make the you have a different opinion, obviously, but let me just make the point. So you have permission to disclose identity information in narrow circumstances under section 24.
Right.
The bill does not prevent expressly the disclosure of transaction logs. Your reasoning is that section 30's obligation to secrecy prevents it. That would, however, prevent disclosure of identity information, but the narrow circumstances in 24 would allow for it. That's one interpretation. The DPA specifically allows for exemptions to the non-disclosure provisions and the first standards of processing, which include disclosure in a number of ways. So let's say it's not, say you disagree and we don't want to include any regulation of transactional data in the NIDS bill. We want it there, but you don't want to put it there. So you rely on the DPA, right? The DPA allows for you to process the data, which includes disclosure, if the data control, in this case, the NERA, has any legal obligation. If any law confers an exercise of a public function to that data control, in which case that would be the NERA, which would be an exemption from the first, which basically a reason to process the data, which includes disclosure. Any exercise of any other function of a public nature, legitimate interest of the data controllers or those to whom the data is disclosed. And then section 24 allows the minister to make an order exempting those standards. So that's as it relates to the disclosure of a person's individual transaction records, which could be feasible under the DPA, which generally isn't a problem because no other entity but NIDS will kind of have that information. But beyond the specific... But beyond the specific thing of the individual disclosure, I would be curious if you want to respond to further. There is also the concern about the anonymized processing, i.e. the creation of profiles, which does not present an individual privacy risk, right?
But how are you going to profile anybody if it's anonymized? Who are you profiling?
No, when I
What
say
profiles are
anonymized,
you creating?
the disclosure is anonymized. So the DPA particularly speaks to this. The DPA allows for exemptions to the standards so long as what you disclose is not personally identifying the data subject, right? And I see Matthew has his hand up. So I would be curious to understand what provisions, whether in the NERA or the DPA, would prevent, for example, analysis to be run on the transaction logs and aggregate data, not identifying an individual, disclosed, which serves a perverse interest generally, but doesn't breach a privacy interest. And I was comforted in a previous joint select committee by a response that you provided, which is that something like that ought not occur because the processing of the transaction logs would only be to facilitate an individual's right of access to their information. That type of limitation, which would reflect a policy intent, is not captured in the bill and is not invocable by DPA. So how would that be a safeguard that one would have?
Okay, all right,
May I just interject, Chairman, may I just interject on this?
Yes, go ahead.
If it is that the concern is about the right to privacy and a violation of the right beyond what would be what would be acceptable and permissible, in that case, I can't see how the issue, I'm grappling with the issue because if, as Ms. Facey has indicated, there is anonymization of the data, which is protecting that actual right. The point is lost on me beyond that.
I believe.
So there are 2 points. So there are two things. There's a privacy issue, Mrs. Bandu-Hufort, which we're kind of going back and forth on. We don't really agree, but we're going back and forth on it. And then there is the, outside of the privacy point, there is the manner and purposes to which the analysis of the data, the processing of the data is put. So outside of privacy, we are concerned, as you've seen elsewhere, that when digital ID providers collect large amounts of data, they then process that data for purposes that are concerning, whether for commercial purposes, political purposes.
Got you. Okay, got you.
And so that stuff, the privacy stuff is separate. Yeah. And so, but I see Matthew, I figure you want to get in.
Yeah. And Chair AG, and I think this is one of the points where we really have to be cognizant of the ways that the technology also facilitates the potential prejudicing of the population, right? Because the information itself, as I think as Kamika was acknowledging, the information itself and what the broader discourse globally around log data is a gray area, right? There are ways in which log information can be stored and can be retained that does not necessarily strictly fall within a definition of personally identifiable information. But the point that we're making is not so much even just focused on that, is that even the anonymized and the pseudonymized processing of that information potentially creates a risk for the population. And so even in case where that information is retained, we need to have some guidelines and safeguards around its processing.
Understood. Thank you for the clarity. Understood.
Okay, but may I just say that, Roger and Matthew, I think I've heard your concerns, and Ms. Facey, that is something that the committee will have to address. To what extent regulations can restrict the use of the, the authentication or the request, so that that does not become a part of any material to be utilized.
So Minister, I see the issue actually as a much wider issue.
Yeah,
I've seen it too.
Across in R&D, in research and development,
right. Exactly.
Right.
What are issues of concern to a segment of a consuming population? How may I better increase the quality of the product or the service that I'm offering, to the extent that data collected reveals certain concerns, even without identifying the particular consumer. So it's a much wider issue.
AG, I accept that.
Is a valid one, but like
AG, what I'm really trying to say is that we need to find a way, and CPC in the legislation, to ensure that we curb the possibility, even the possibility of these requests and authentication being utilized in any way outside pure identification. That's the point I'm trying to make. In other words,
and Minister, if I may, additionally, we are not beholden to the way that we have crafted our recommendation. We've expressed the intent. So if in drafting, the team can find a way to address these concerns that is not the way that we have recommended, we are totally okay with that. But we are concerned that it doesn't seem to be fully addressed. And I know that we're wrapping up, but a good example of this is a special request I have here in Ms. Facey's response. In responding to the identity information piece, she was at pains to say that, we're either maybe being a little bit unreasonable in the interpretation that we have, because an application would only ever be denied if someone provided insufficient information, and that inaccurate information would never be a basis for denial. This is actually our request that this be put in the bill, because somebody else, just an example of this, no, but it's not, Miss Facey. It says in the bill that the authority has a broad.
Hold on, Miss Facey.
No, but I'm saying the constraint. No, the constraint and the discretion is what is not in the bill.
May I respond to you on this? Hold
If you
on.
wanted the response before you
Just before Miss Facey comes in, Chairman, just before Miss Facey comes in, the bigger point that I understand Mr. Malcolm and his team and others have made is care must be taken in the language use, because whereas the intention may be one thing, if there isn't a careful drafting of the provision to accurately reflect what is intended, the law is being used by different persons and one may interpret it in a particular way. So the big point is just the care in the language used in the provision.
Okay. Could we hear from the
Agreed, Madam AG.
Hold a second, Mr. Malcolm. Judith, the CPC, Judith Grant would like to intervene. CPC, you wanted to make
thank you, Chair. Yes, care should be taken in the language, but care should also be taken in the reading. And I noted, Ms. Facey had mentioned clause 30, but also one could also have a look at clause 23, which also speaks to information generally, not just identity information. And that really contains some provisions dealing with how information should be secured and kept confidential, and requires that technical and manual security measures be taken to protect the information, not just identity information, from unauthorized access, unauthorized use, unauthorized disclosure, and any loss or distortion.
Yes.
Good addition, Madam CPC.
But the issue is that it is not unauthorized CPC. Madam CPC, it would have been authorized. The issue is not that it's not authorized. But moreover, it only applies, final point, it specifically applies things like encryption only to the identity information. Just for example, in several places throughout the bill, it establishes that it specifically applies certain things just to identity information. I think the point is clear, apart from just like defending that you could read.
23, please.
But all right, CP, it literally says it. But I understand. I hope that these are considered. Yeah, I'll rest.
Judith, you wanted to respond? Or you did already?
I did already, Chair. Thank you.
All right. No, just a second. Ms. Facey, you're going to just update the responses for the Jamaica Justice and its the team, civil society team, so that what we would say, Mr. Malcolm, please, if there are additional concerns after the responses are sent, we don't have a problem you send in some written comments. Okay. So what I want to do now, we have a lockdown, and people want to go and do some business. So if you don't mind, we have some final comments from you, Matthew and Ronjay.
Well, I suppose just
Sorry.
I was gonna maybe just ask a quick question. I don't want to sort of own up another can of worms, but one of the important parts of the legislation relates to the Data Protection Act and what operationalization means. I don't know if the Joint Select Committee or the project team has a quick response on how we're ultimately treating that.
we can't speak to the operationalization of the DPA. We can, however, indicate that we believe that there are other mechanisms for data protection elsewhere within particular industries, within this particular bill, that will still be useful for persons should the DPA not be operationalized and or operationalized, but in a particular manner for NERA only.
Okay, thanks. Ranjay, any points?
Okay, thank you. Yes, so in closing, one, really just a lot of gratitude. This is the first Joint Select Committee that has given me written responses to the different things that we have said. And I want to genuinely congratulate you on demonstrating consideration of the points, notwithstanding the disagreements. In closing, I want to reiterate and clarify where I think where the AG kind of took us, which is that, yes, we need to have careful interpretation, but as you've seen throughout this process, multiple people have come with very similar interpretations of how this provision, particularly on identity information, other information, are interpreted by them, counsel, law professors, and the responses have been kind of the same.
Hold on,
Yes,
I said what I know, you slipped it there. I was actually aiding you by saying I understood your submission to be given the multiplicity of interpretations of provisions. So, but I think you just reversed it.
No, I'm saying I'm agreeing with you, Madam AG, that there are multiplicity of interpretations from several persons, and you have suggested that greater care, notwithstanding maybe the positions that the drafters may have about the precision of the statutes, great care is needed to avoid undue multiplicity of interpretation for something that should be clear. That's how I understood it.
Just to say though, hold on, just to say though.
I thought I was.
Yeah, hold on, because it's a exchange that is taking place. It's spirited. The issues, we're dealing with frontier issues. No, but drafters draft in accordance with instructions and their understanding of the policy. So it's not an attack on the drafters. It's not just a number of things are coming up. So when the CPC in helping to respond say, let us read the provisions carefully also, because sometimes things are written there, but we read them differently. And there are other times we're reading what is there, thinking that what we meant is actually reflected there. So the takeaway is that we will go back and we will look to see that what we are refining as the policy intent behind each provision, behind the entire law, that those are accurately reflected in the words.
Okay, all right. Thanks.
Certainly, yeah, no dispute there. So in closing, on the issue that has led to the greatest interpretive difference, what I would suggest is that we agree up to a certain point on the authority. We agree that the bill says may, that all of these attributes may be required. We agree that the authority has a discretion to require some or all of these attributes. Where there is an interpretive disagreement, at least in this discussion, is the degree to which that discretion is appropriately constrained to prevent the concerns that we have articulated in our submission. We would appreciate if greater clarity could be just extended in constraining that discretion, because it is in the use of that discretion that the entire menu, as you put it, could be mandated in a variety of circumstances, changing over time. So we would appreciate it.
Thank you very much, Mr. Malcolm.
All right, thank you very much, everybody, and I wish you all the best in your lockdown.
We're going to adjourn in another 2 minutes. Just to ask Grayson Morrison, please, can you, as soon as possible, send the list, just the list, because you have circulated already, all the written contributions and the responses to the written contributions, to ensure that all members of the Joint Select Committee are aware of all the written submissions. There are over 103, but just send the list again for me, please, Grayson Morrison. We're not going to meet next week, members of the Joint Select Committee, which would give members the opportunity to go over many of these presentations and also the responses to the presentations. But in the week of April the 19th, I would certainly want to start start setting some dates where we can start to consider the bill so that a report can be tabled in Parliament towards the end of April, early May, so that Parliament, we can report to Parliament no later, hopefully, than May. So please, Grayson, just trying to put all the minutes up to date, and also to remind members of all the written submissions that came in and the responses. So Jamaica to Justice, I want to thank you for the tremendous amount of time you put into examining the bill. You certainly have caused a number of reflections, and many of the points you raised will assist us as we deliberate on the bill. So thanks again.
Thanks, Chair.
And
Thanks,
also,
members of the
Thanks for having us.
not only to Jamaicans for Justice, but also to all the other contributors. Okay, so thanks again. And can I have a motion for adjournment?
So moved.
Thank you very much. Thank you very much. And thanks again. We will be in touch with all the members of the Joint Select Committee during the course of not next week, but the following week. Thank you very much, everyone.